Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Apologies, starting just a couple of minutes late, but let's get going with Judge Glazer in Miami-Dade.
Are you guys from the jail? You guys from the jail and stuff like that? Yeah. No, they do that. The jail correction, you have her booked on the calendar as male. She should be listed as female, just to be clear, okay? You want me to reset it for the afternoon?
Yes, Sean, I'll go ahead and reach out.
I don't know. He can try. With violations of probation, it's hit or miss. Because it's a misdemeanor, maybe they'll agree. All right. See you later. Next, we have Liliana Falcone. You got corrections out of turns? Renee, did you see the case corrections needs?
No.
Oh, they wrote it here. 17, 20, 20. These are the lottery numbers for today. 17, 20, 23, 27, 50, 57, and 58. There's an extra number though for you. Good morning, Miss Falcone. You were arrested. Good morning. Is English okay?
No, Spanish.
Okay, thank you. Ma'am, you were arrested on a warrant from Collier County, Florida. The warrant was issued February 11th of 2025.
I know.
Tiene una orden de arresto del 11 de febrero de 2024 en el condado de Collier.
The
Sí.
charges for violation,
Probation.
oh, it's violation of probation.
Sí, es por incumplimiento de libertad condicional.
I will appoint the public defender's office for you.
Le voy a asignar un abogado de oficio.
So unfortunately, there's no bond on the warrant. And so you're going to have to wait up to 15 days for Collier County to come pick you up.
Desafortunadamente no hay fianza en esta orden de arresto. Sí se va a tener que esperar 15 días hasta para que el condado de Collier venga y la recoja.
Your case is reset here August 28th to make sure Collier County has come and pick you up.
Su caso está reprogramado para el 28 de agosto para que el condado de Collier venga por usted.
All right, have a nice day, ma'am.
Que tenga buen día, señora.
Gracias. Igualmente.
Welcome. Thank you. Anise Avilas is next. Got a lot of ladies today.
You want Spanish?
No, I speak English.
Good morning, ma'am. You were arrested.
morning.
Good morning. You have an arrest warrant from Broward County that was issued July 29th of 2025. It says felony no-show capias for burglary to an unoccupied structure and petty theft. I will appoint the public defender's office for you. Unfortunately, there is no bond and you're going to have to wait up to 15 days for Broward to pick you up. The reset
I
date
was
is
in
up.
custody here when that was issued.
I know they issue warrants as a whole, but Broward usually comes once a week, so hopefully you won't have to wait that long. So the
Okay.
reset date's August 28th, just for us to make sure you've been transported there, okay?
Thank you.
Have a nice day. Good luck to you, ma'am. Next is Kiara Vargas Reyes.
Your Honor, she has a hold for immigration.
Thank you. Good morning, ma'am. Is English okay?
Spanish, Your Honor.
Spanish. Ma'am, good morning. You have an arrest warrant from Martin County, Florida.
Sí, señora, tiene usted una orden de arresto del condado de Martin, la Florida.
The warrant was issued April 17th of 2025, and the charge is retail theft with others.
Sí, la orden de arresto es del 17 de abril y esto es por robo a tienda.
So, the public defender's office is appointed and you can talk to them if you have any questions, because you do also have an immigration hold.
Ha sido asignado un abogado de oficio, les puede usted llamar, aunque también tiene una orden de retención por el Departamento de Inmigración.
Your bond is $10,000.
Su fianza está fijada en $10,000.
If you want to post a bond, you can do so at the jail you're located at. And if you don't post a bond, Martin County has up to 15 days to pick you up.
Puede usted depositar la fianza en la cárcel donde se encuentra y si no deposita la fianza, el condado de Martin tiene hasta 15 días para venir por usted.
The reset date is August 28th to make sure you either posted a bond or were transported to Martin County. Have a good day.
Se fija la fecha para el 28 de agosto para dar oportunidad a que el condado de Martin sea transportada para allá. Que tenga usted buen día.
Pues
All right.
yo ya pagué la fianza.
I already placed bond.
Then you should be able to post the bond. But then usually they make you see a judge first. That's why.
Sí, por lo regular lo hacen que hable usted con el juez primero, es por eso.
Okay,
Okay.
good luck to you. Corrections, when I finish the warrants, I want to call up Marie Stubbs. I have a victim here. All right, next is Hasib Khan.
She has to go for deposition, little trial.
I'm also calling up at intern Sean Harrington for an officer who needs to go somewhere else. So that will be first. Okay, good morning, Mr. Khan. You have an arrest warrant from Sarasota County, Florida. The warrant was issued December 28th of 2022 for violation of probation. So I will appoint the public defender's office for you. Unfortunately, there's no bond on the warrant. You're going to have to wait up to 15 days for Sarasota County to pick you up. The reset date here is August 28th to make sure you are transported. And if you have any questions about the warrant, you can call the public defender's office, okay? Thank you, sir. Have a good day. Shermont Wiley, did I do that one? Yes, okay. Then we have Yorande Ramirez Ramos.
Your Honor, he went to family court today. We need to reset it for tomorrow.
Reset for tomorrow. I'll appoint the public defender's office. It's also a hold for agency, so I'm not sure. What is it? Yes.
I emailed Collier County, Ms. Karimi emailed me back, said that it was originally, he was there. He was brought down by an order from a day judge, and they just simply want to hold because they're going to transport him back there to
All
Collier.
right, let's set him tomorrow to make sure he's on the list. Corrections, is he gonna get on the list or, we'll set it tomorrow, make sure he gets on the list for pickup.
Yes, Your Honor.
Make sure you mark it because they may not put on the calendar, may drop off. Next is James Smith. We have James Smith.
Your Honor, he refused court.
I'll appoint the public defender's office. He has a no bond warrant from Seminole County. Reset date will be August 28th. Next is Kania Said. Is she
Bonded
there?
out.
Thank you. Nelson Mondesir.
Coming up.
Thank you. Good morning, sir. You have an arrest warrant from Brevard County, Florida that was issued on November 29th of 2021, and it's for violation of probation. So I will appoint the public defender's office for you on this warrant. Your total bond is $5,000. If you can post that bond, you can get out of jail. If you do not have money for a bond, you will have to wait up to 15 days for Brevard County to pick you up. The reset date here is August 28th to make sure you either bonded out or were transported. All right?
Okay.
And if you're going to post a bond, do it at the jail you're located at. You'll get out quicker.
I believe my brother is supposed to be posting a bond.
They make you come see me first. Okay. Have a nice day.
You
Next
want-
is, what?
To come see you.
No, I'm sorry.
You had to come to court to see the judge first before they'll accept the bond at the jail, I believe, because it's a VOP. Next we have is Felix Lopez. Need more left. Hi, Mr. Lopez. Good morning. You have an arrest warrant from Monroe County, Florida. The warrant was issued May 31st of 2024 for failure to appear for no driver's license. I will appoint the public defender's office for you. Your bond is $10,000. So if you're able to post a $10,000 bond, you can get out of jail. If you do not have money for a bond, you will have to wait up to 15 days for Monroe County to pick you up. The reset date here is August 28th to make sure you either posted a bond or were transported in Monroe County. All right?
No problem.
Have a good day. Thanks.
you.
Mark Crowley is next.
Stand here, look at the judge.
Good morning, Mr. Crowley. Sir, you have an arrest warrant from Hillsborough County, Florida. The warrant was issued on February 15th of 2024. The charge is failure to appear for solicitation and distribution on a public road. Your bond is $250. I will appoint the public defender's office for you. If you're able to post a $250 bond, you can do so at our jail, the Dade County, the TGK jail where you're located. If you do not have money for a bond, you will have to wait up to 15 days for Hillsborough County to pick you up. The reset date here is August 28th to make sure you either you bonded out or were transported to Hillsborough County. Have a good day.
Hey, you.
Thank you, sir. Next is Charles Womble. Is he here or did he bond out?
Oh, he's here.
Mr. Womble, good morning. You owe child support. A writ of bodily attachment was issued for you by Broward County and the cash purge is $1,065. So I am appointing the public defender's office for you. If you were able to post a $1,065 cash purge at our TGK jail, you should do so that you can get out of jail. If you do not have any money to pay that, you're going to have to wait up to 15 days for Broward County to pick you up. So you understand?
Yes, the phones are down at the moment, so I cannot call the.
I hope you can call and get out, sir. In the meantime, the reset date is August 28th to make sure you either were transported to Broward or that you post your cash purge. Okay?
Okay,
Have a nice day. Thank you.
same to you.
Thank you. That's it for the in-state warrants. Let me call one and then the other. Right now out of turns, Sean Harrington, is that the one? These are the correction ones?
Right.
And then I told this lady I'd call her. She got a baby. Are you here for the Sean Harrington? Okay. You wanna come?
Page 15, number
Hey,
50.
Thank you.
Your Honor, he refused.
He refused court. Good morning. Did you want to say anything? We'll swear you in. I can take notes.
I do, Sergeant Melissa Rodriguez, Miami Beach Police Department.
Okay, how can I help you?
Sean Harrington is a habitual offender in our city. He's served time for criminal mischief. He's vandalized our police cars back in 2020 and 30. He was just convicted, well, he was arrested for aggravated battery, but they lowered it to battery. He was just convicted August 4th. He continues to be in the city. He just sprayed the victim in the face with like some liquid form of like blood or something like that.
Is that for this case or the other
Yes.
case?
That's this case.
I need a moment to review. And also I'm appointing the public defender's office for him.
And one more thing, Your Honor, he does receive bond money from, he has a BMO account on social media, he receives money, so an elevated
That-
bond would be good. He continues to just escalate his behavior, his violent behavior.
Let me review this arrest affidavit.
Your Honor, he's coming in right now.
Isn't that nice? They found, I guess he didn't refuse.
Maybe your levels here.
He maybe want to see you.
Yes, he loves.
Good morning, Mr. Harrington. Sir, you were arrested for a case from August 12th, which was yesterday. The charge is battery with a prior conviction. So, sir, can you afford to hire a lawyer?
Ms. Glazer, at this point, I have not read the affidavit.
Let me appoint the public defender's office for you. I'll tell you what it says. It says the victim wants to press charges. It happened at the Hotel Marseille. You were allegedly harassing pedestrians and hotel guests at the hotel. The hotel supervisor stepped out to ask you to please vacate the area, but let's see, it says you produced a small spray bottle from your pocket, pointed it at him and stated, "Do you want the smoke?" The victim believed it to be pepper spray, at which point he turned and began to walk toward the front desk to call the police. And then the defendant sprayed him with an unknown liquid, causing a red stain which appeared like blood. The victim's clothes were soiled with the unknown red liquid that was sprayed on him by defendant. And then it says you have prior convictions for battery. The last one, May 25th of 2025. So those are the allegations. Just so you know, Sergeant Rodriguez is here from the Miami Beach Police Department, and she was asking the court to give an elevated bond because you keep causing, I guess, some issues in Miami Beach. So that's what's going on. In the meantime, you're ordered to stay away from the alleged victim, whose initials are BN. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. You are also ordered to stay away from the Hotel Marseille, I think it's French, at 1741 Collins Avenue in Miami Beach, Florida. Do you understand the stay away order, sir?
I do understand the stay away order. Can I please?
Appointing the office of the public defender.
I want to discharge
Yes.
it. I can afford an attorney. Hold on.
Do you work?
What do I do?
Yeah, do you work?
Yes, every day.
What do you do for work?
Whatever it takes.
That's a good job to have. Are you
Yeah, it's a
happy
great
doing that?
job. Yeah,
So
I mean,
listen, for now, let's be serious. For now, it's
I am
important-
very serious. I'm just concerned about as far as the distance from their property line. There's a project next door, and I think when I get to court, I can explain this out. But I was just explaining to the man that he has a bunch of trash on our property, and he said,
One moment.
So the lawyer, I'm appointing the public defender's office for you. If you want to hire a lawyer at a later date, you can do so, but it's important you have legal representation. Just for the record, he has conviction of battery for August 4th. He has a conviction, it says nuisance, May 20th. Drinking alcohol in public, May 20th. Disorderly conduct is 2024. From 2025, he has petty theft, May 20th. Aggravated battery, that was the one I guess reduced. That was reduced to a misdemeanor. Then he has more. A lot of no actions from 2025. Okay. Ms. Corey, can I proceed and set the bond? So Sergeant Rodriguez was asking for an increased bond, and I think I agree with her. So I'll set his bond at $10,000. All right. Good luck to you, sir. Is that okay? Have a good day.
Judge,
how
just to
far?
clarify for him, how far does he need to stay away from the hotel?
500 feet away from that Hotel Marseille. There's so many hotels on the beach. Find another
I
one to go.
work next door. I work across the street and next door. That's way too far. I will not step foot on their property, but my entire world of work is within 500 feet. That whole block.
What
I
is
was
what is next
arrested.
door there?
Miss Glazer, I was arrested at my
Your Honor,
employer.
I've been
What's
present
next door?
at prior bond hearings for Sean, and he always has the same story. Wherever a crime occurs, he's always working in that area.
Maybe he is.
Yeah, no.
Let me see. What's at Hotel Marseille? I don't know. Hotel Marse. 17th and Collins. So what's over there? We'll see. I'm trying to see what's over there. So what's the name of the building you work at?
Well, there's multiple buildings, but my building is in Los Angeles, but where I work is next door at the Raleigh project is now a up for grabs project. So I'm trying
Okay.
I'm trying
While
to
this-
finance that project, and then we've got the SLS on the corner.
So
so-
well, you're gonna have to have one of your agents do that because you are ordered to stay away from the Marseille Hotel. All right. Have a nice day.
So the more to this story is that across the street from the Hotel Marseille is a bar named Whatever It Takes. And that's where he actually works. Oh, good morning, everybody. Welcome once again to the Courtroom Files Live. Happy Wednesday. I love this job sometimes. It is so much fun hanging out here with all of you and listening to some of these people. Let's stay in Florida but head north and say good morning to Wade Mercer.
Before he gets here, we can address that case a little bit early.
Yeah, Mr. McDaniel shaking his head yes. So as soon as he gets here, we'll jump in and try to resolve that, see where we stand in that case. But he's
Okay.
not in the courtroom yet, okay?
Yes, sir. Thank you.
All right, so on first appearance list, yes, sir. First appearance list, the first case is Joshua Caraway. Mr. Caraway, come on up. The corporate's going to show you where to stand. Mr. Caraway, good morning. You're here because you're accused of violation of probation. You've got two different warrants for that. You've got a Jackson County violation of probation allegation with no bond. You also have a hold for Calhoun County, same allegation, violation of probation with no bond. What I want to do in the Jackson County case is go ahead and arraign you and get you a lawyer appointed if you're asking for one. Now, I do know there was a notice of appearance in the Washington County case by a private attorney. I did not look to see if the private attorney had filed a notice of appearance in the Jackson County case. Do you currently already have an attorney appointed to represent or hired or appointed to represent you in the Jackson County VOP, sir?
No, sir, not at this time.
Okay. Now, Mr. Morris had filed a notice of appearance in the Washington County one, but he had also filed a motion to withdraw.
Yes, sir.
And that has not been ruled on. And that is the same status as Jackson County. So you have an attorney that's appointed to represent, hired to represent you, and he's asked to withdraw, but he's not withdrawn yet. Are you in agreement with him withdrawing as your attorney?
Yes, sir, but I don't know how long he's, I don't know if he's supposed to handle Jackson County and Calhoun County for me and be done or what. I'm not sure.
Okay, so here's the situation. I cannot appoint you to the public defender's office if you already have an attorney. That attorney has filed a motion to withdraw, saying that he no longer wants to represent you, and that motion to withdraw is not signed by you. So if you tell me you're okay with him withdrawing, then I'm going to grant the motion. I'm going to appoint the public defender's office to represent you starting today. If you're not okay with him withdrawing, then I cannot appoint the public defender's office to represent you. So the question is, do you want to allow him to withdraw as representing you or not?
I mean, no, I'd still like for him to finish his job. Yeah.
Okay, so I'm not going to grant the motion to withdraw. We'll see what happens on that. That'll be something Judge Garcia will decide. So I cannot appoint you a lawyer today. So as of right now, he is still your attorney. You'll still get on the court date that you're supposed to get on, which Mr. McDaniel, when would that be?
September 2nd.
You'll be on the September 2nd court date. And as of right now, Mr. Morris is still your attorney. And you'll see the judge on September 2nd. Any questions, sir?
No, sir.
Have a good day, Mr. Caraway. Sean Daughtry. Mr. Daughtry, good morning. Mr. Daughtry, you here for a hold out of Wakulla County? I've got a copy of the warrant in front of me, sir. It has a $2,000 bond. If you post that bond, Mr. Daughtry, you're going to be released. If you're not able to post the bond for Wakulla County, you'll be held until they pick you up and you'll go to a first appearance there. Let me see if there's any other special conditions on the bond. I don't see any other special conditions. Do you have any questions, sir?
I was incarcerated here when they filed the FTA. Does that have anything? I guess that still
It
doesn't
may
matter.
be relevant. It may be relevant. So here's what I'm going to do. It depends on sometimes the failure to appear is based upon you being in another jail. But the question is, were you in jail because of a new offense? Because if you're charged with a new offense, then you very well may have violated the condition of a bond. Let me finish. You may have violated the condition of a bond. If it's an old case that you were in jail for, the judge there may be made aware of that and may modify the situation. So if you don't post the bond, I'm going to ask the jail to give you some documentation to take with you from our jail showing the date you were in custody and the day that you were released. They'll send that with you when you go to Wakulla County. If you post a bond, you'll be released from here. Okay?
All right. Thank you, sir.
Yes, sir. Have a good day.
You as well.
We have John Williams next. Mr. Williams, good morning. Mr. Williams, you're here for first appearance accused of one count of driving while license suspended or revoked with knowledge. Mr. Williams, I'm going to appoint the public defender's office to represent you. I'm going to tell you there is probable cause for this charge. And Mr. McDaniel, is this a bond analysis? Bond. Anything from the defense? No, Your Honor. And Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Williams, I'm going to set you the standard bond I set for this charge for someone with your criminal history or similar criminal history. And that's $2,500 cash or surety. Mr. Williams, cash or surety means you don't have to come up with all $2,500. That's an option if you wish. But if you want to go through a bondsman, and if they charge you 10%, that'd be about $250 to get out of jail. Mr. Williams, you will get a chance to use the phone after first appearance to try to post the bond. Your bond has a condition that you not drive a motor vehicle unless you have a valid license. So to get your license issue straightened out, you can certainly drive. Until then, you cannot drive a motor vehicle. Do you have any questions?
Yes. What jurisdiction do you have over me? Are you a common law judge or are you a commercial law judge?
I'm
Because I'm not
a
a
state
driver.
of Florida. I'm a judge hired by the state of Florida to represent the citizens of the 14th Circuit. Any other
Okay,
questions?
so is that uniform commercial code law or is that common law?
I'm a Jackson County judge. It's neither. Do you have any other questions? Have a good day, sir. Next case is, we have Mr. Rico next. We don't have an interpreter. Actually, do have an interpreter up there. So,
Your Honor, good morning.
Mr. Cordova. Let's go to Mr. Rico. Sorry for the late notice.
It's okay.
Mr. Cordova, there was a mix-up with the jail, and someone didn't realize we needed an interpreter until very, very late today. But thank you for getting in on short notice.
No
Please
problem.
introduce yourself to Mr. Rico and make sure that he can hear you, sir.
Buenos días, señor Rico. Yo soy Jonathan Córdoba, el intérprete para hoy. ¿Sí me escucha bien?
Sí, escucho bien.
Yes, I can hear well.
Great, thank you. Please translate from me. Mr. Rico, you're here because you're accused of one count of violating the terms of your probation.
Buenos días, señor Rico. Usted está aquí porque está siendo acusado de un cargo de que está violando su libertad vigilada.
The case number is 24-342-MM.
El número de caso es 24-342-MM.
The allegation against you is basically that you did almost everything in your probation except the following.
La alegación es que cumplió con todo lo que le estaban pidiendo, menos lo siguiente.
According to the probation office, you never provided proof that you went to anger management counseling as directed.
Lo que están diciendo el agente de libertad probatoria es que no dio pruebas de que cumplió la escuela o la clase de enojos que tuvo que hacer o terminar.
Mr. Rico, the offer being made to you today is if you admit your violation of probation, you'll be sentenced to 30 days in the Jackson County Jail.
La oferta que le queremos hacer ahora es que si usted está de acuerdo que incumplió su libertad vigilada, le vamos a condenar a 30 días en la cárcel del condado de Jackson.
You would have 6 days credit for the time you've already served.
Tendría crédito de 6 días por esos 6 días que ya ha cumplido.
However, if you did complete some of the anger management counseling and can get proof of that, that sentence may be lowered.
Pero si sí cumplió parte de ese curso que tenía que cumplir, el de enojo, entonces quizás esa condena puede ser menos.
So option 1 is to say, I want to admit I violated my probation and go ahead and take the 30 days with a 6 days credit.
Entonces la primera opción es que usted sí acepta la oferta, que sí admite que tiene culpa y le van a dar 30 días en la cárcel.
Option 2 is to say, I would like to talk to an attorney in private, in which case, if you choose that option, I'll see you tomorrow.
Y la opción 2 es que usted le gustaría hablar primero con su abogado y si escoge esa opción, entonces podemos continuar hablando mañana.
The second option would give you or your attorney time to try to get some verification of the classes you may have done.
La segunda opción les daría tiempo para usted y para su abogado para investigar sobre esa clase que tiene que tomar.
Do you have any questions about those choices?
¿Tiene alguna pregunta sobre esas opciones?
No, así me quedo los 30 días.
No, I'll go ahead and take the 30 days.
That's what he told me out here too, so. Like I say, he's really nice guy. So Mr. Ham told me this, you can translate this, please. His probation officer, Mr. Ham, told me this morning he did everything asked of him except the proof of classes.
El señor Ham, que es el agente de libertad probatoria, dijo que usted terminó todo menos ese curso que se le estaban pidiendo.
So I was hoping he had went at least to some of the classes so I could adjust the sentence accordingly.
Entonces yo estuve esperando si usted cumplió con algo de esa clase, entonces pudiera ajustar la condena un poco.
Try to tell Jake that.
Yo pregunté ahí en la escuela donde iba y me dijeron faltaban 4 más.
I went to that course and 4 months had passed.
¿Dónde?
¿A dónde, señor?
No me acuerdo cómo se llama, pero faltaban 4 clases más.
Oh, I don't remember, but I still needed to do 4 classes more, 4 more classes.
If you know where you went and we can verify that, that offer would be lowered.
Si usted puede averiguar a dónde fue y confirmar eso, entonces la oferta sería menos.
Señor Goodson, en español, por favor.
Okay. He was going to go to Dr. Spires'
Give time for that to translate, Mr. Goodson. So
he can't.
I need to make sure that he hears what Mr. Goodson's saying because the notes say that he went to some counseling. So, Mr. Goodson, please start over.
And Your Honor, I'm sorry, I can't hear. Okay, now I can hear.
We're going to start over, please. Thank you.
According to our notes, according to Mr. Rico, Dr. Spires did have a Spanish-speaking counselor.
Según las notas, notas del señor Rico, el doctor Spires sí tuvo un consejero que habla español.
For approximately 4 different, almost 5 months, Mr. Rico had informed Mr. Ham that he was going to Dr. Spires' counselor.
Y por aproximadamente 4 o 5 meses, el señor Rico le dijo al doctor Spires que estaba yendo a esa clase.
So, Mr. Rico, if you wish, we'll pass your case until tomorrow and verify with Dr. Spires how many classes you were able to go to.
Entonces, señor Rico, si está bien con usted, vamos a dejar esto hasta mañana para averiguar con el doctor Spires cuántas clases, cuánto le falta todavía.
Would you like for us to do that?
That's fine.
Okay. We'll see you in la mañana, okay?
Nos vemos mañana.
Sí. Está bien,
Yes.
gracias.
That's fine. Thank you.
Thank you, Mr. Cordova.
Thank you, Your
Mr.
Honor. Have a
Cordova.
good day.
All right, I'll keep an eye on Judge Mercer's court, but let's go to Texas and say good morning to Judge Stevens.
Public intoxication within a week of being placed on probation. And considering his bizarre behavior at the probation office and concern for well-being and the safety of others, it is recommended that the court consider modifying his term and placing in substance abuse felony punishment facility placement. So that's the recommendation. Safe Pete. All right. Anybody want to add anything to that? At least we're keeping him on probation, if that's what you want to do. We can also, or I can also order a motion to revoke probation.
No, I think, no, you're gonna stay on probation, just do the same thing. Yeah, I think he's gonna do that. Yeah, I'm gonna stay on probation, I'm trying to complete that, Judge, I'm trying to do that.
You're not trying hard enough Sir,
Yes.
sir, you're not trying hard enough.
Neither time
You,
was on.
you're gonna just keep interrupting all day. You're just rude. When I speak, stop, because you can't take two people speaking over each other. We learned that when we were in kindergarten. I remember, don't interrupt us. Are you through interrupting me? Okay, I'm gonna speak. Don't speak, and then I'll point to you, and then you can speak, because we gotta now use these rules. This court can order a motion to revoke probation. Then it would be in this court's 18 and a half years here, one of the quickest revocations of probation heard about and known about. And this is worthy of revocation, because when we stuck our neck out for you, you immediately, within hours, you were showing up apparently intoxicated, arrested for intoxicated, and then released and come right back and start acting bizarre, as though there are some substances that may be in your system that cause you to act erratically, which is all it takes to revoke your probation and send you to jail for 2 years. What we're going to do is deal with this. Since you're not seemingly handling this responsibly, we're going to do it. You're going to be ordered as a condition of probation to attend and complete the substance abuse felony punishment facility. You will go to a facility, and they will work with you to try to maintain your sobriety, so that you are not intoxicated by whatever substance this was that got into your system that caused you to act bizarre. And it's a good thing. I find that it is generally fixes and helps most probationers when we send them to the facility. But you've got to do your part by participating responsibly and following the directions. It's a hospital-like facility. Can you do that? Yes, sir. Sir, can you do that? Can you cooperate with them and do your best?
But I just want to state for the record, I wasn't intoxicated, nor was I on drugs or alcohol. I stated to everyone, give me a drug test or some type of alcohol test or anything, so that we could know if I was on drugs or alcohol. Neither time was I on drugs or alcohol. And there's no concrete evidence.
So what was the problem? What was the issue?
That's what I'm asking. That's what I'm wondering. I'm trying to complete this program the right way, trying to do it the right way. I understand there's obstacles. I understand there's things that are in front of me that, I got to overcome, which I'm trying to do that. And I'm continuing trying to do that. There's really no reason for me to go to safety, but I mean, that's what you're asking. That's
all right.
I got to comply with.
Then if you don't want to do that, then I'm going to order a motion to revoke probation, and then we'll handle it that way. Yeah, because you don't dictate the terms of your probation. You don't dictate it, especially somebody who within hours is lying face down next to the roadway, apparently intoxicated in the grass, and then the next day appears into the probation office and starts undressing and acting bizarre. Is that normal for you?
I mean,
is it normal? Is that normal for you to be acting that way and then laying down, face down next to the street in people's yards? Does that happen a lot?
I do not know if that happens. Like
okay.
Me, no.
Has it ever happened?
With me?
Yes,
no.
sir.
And the whole taking the shirt off is just making sure that they knew that I didn't have no weapons, because they wanted to state to them, I took off. I told them I didn't have no weapons.
Is that what you normally do? You just go into places and start taking off your clothes to ensure that people know that you don't have weapons?
Well, I was in the probation office.
Yes. Who said you had to do that?
It's just, it's.
You think, that's normal courtesy, you think?
To them, to them, Yes, I thought that. I thought that.
You're absolutely wrong. But it's bizarre. That doesn't happen. We have 5,000 probationers on probation. They don't go in and start undressing on a whim. We're going to figure out, SAFE is going to work with you to figure out what the root of this problem is and try to fix it. Okay? Work with them. Be responsible and cooperate with them. Can you promise to do that?
Yes, sir.
Don't take your clothes off unless you're required to in a public place, and follow their instructions and directions. They're there to help you.
Sure.
That's what we want. Okay. Anything else?
When is
you're gonna be taken into custody and then sent over to the facility to get you help, and we'll get you back out here, and hopefully all will be well. We get reports how you're doing. Again, we want you to be successful on probation because we're proud. You got a 93% success rate now. We want 100%, including you. So do your part, okay?
Yes, sir.
Yes, sir. Okay.
Thank you.
Thank you.
Maynard is the other one.
Lindsay Maynard?
What I did was give him opportunity to decide if he was going to take the 3-year cap or not. That was the new offer. When we reported last, the offer was an 8-year cap.
Oh, okay.
Mr. Laird has now made a 3-year cap. So I wanted to have time to discuss it.
Come on up. Come on up, sir. Are you're Lindsay Maynard? Yes, sir. Come on up.
If he decides to take it, I sign him. If not, it's on him. But that's the new offer.
So while we're waiting for the next contestant to come up, as has suddenly somehow become the case so often here, I'm following breaking news. It appears in Louisville that there was a shooting at a school bus stop. It was a adult female who was shot by somebody this morning. Apparently she was there with her child. That's what the early reports say. She's been taken to the hospital. Nobody has been apprehended on that yet. Some reports say there was as many as 3 shooters. And then I believe this was up in the Cleveland area. A bus crash. The bus turned, Cleveland ISD was the bus. Bus crash. It flipped over on its side. Apparently no serious injuries there, but not a good morning to be a school student from the looks of things. Anyways, that's what I've got my eyes on over there. Let's go back to Judge.
It's EMS. Let's see. Yeah, EMS personnel, which is a 3rd-degree felony, which carries with it, you probably know intimately here, up to 10 years in prison. And in an abundance of caution, we have evaluated you, it looks like twice, for 2 different reasons at the request of the this court, and you, because of good reasons, we felt like you needed to get evaluated by medical personnel. You are deemed competent, and that in the other report regarding sanity. Is this one? Is this one? That the findings were that, I remember this set of facts, that your mental capacity may substantially have been impaired due to drug usage, which is, as you know, under the law, is not a defense. Voluntary use of drugs, what reactions you may have to that, and disturbing. Are you going to just interrupt me? Are you going to interrupt? She can't take. I just talked to the last guy, and she can't take when you're interrupting and they're all talking at the same time. Tell me when you're through mumbling.
Yeah.
Are you through? Okay, well, let me speak. And, anyway, that is not a lawful defense. So you're looking at up to 10 years in prison. I think the state had offered
8 year
cap of 8, and they have gone down to that. They have gone down measurably to a offer of a cap of 3 years, which would, if that was accepted, you would be looking at no less than 2 nor more than 3 years in prison, based upon the court's determination. I can also place you on deferred or unadjudicated probation and also regular probation, right? So you have 3 options there that the court can consider doing with the cap. The worst scenario of your of all of that is no more than 3 years in prison. So what are we going to do? Which way are we going to take it? Please talk to you. These are your options. It's time to make a decision.
Can I say?
Yeah, speak. Go ahead.
Since the last time I saw you,
Yes, sir.
I have
Done well.
no, I had a seizure when I was here last time,
Okay.
and I spent a lot of time in the ICU.
Where? Which one? St. E?
I was there first, and then she moved me to another one because I was not getting the proper care.
Really?
She's
St. Elizabeth wasn't providing the proper care?
She's my caretaker.
Who is?
That lady right there.
Who is she?
She is my wife. She's an
Okay, she's your wife.
Yeah. She works works dementia. I have I had a traumatic brain injury and a head-on collision.
When was that?
A couple of years ago.
Okay.
And I had severe seizures. That caused me a lot. I was in the ICU for quite some time. Since the last time I saw him, and I've been taking a lot of medications for my. I was going to say I've been sober and clean for 5 years.
This probable cause affidavit that resulted in this indictment of assault, this states that who is Lori Benaja? Is that her?
No, that's the nurse.
The nurse. Okay.
That's St. Elizabeth.
Okay. She was the one who was assaulted.
Yes, sir.
In this event. And this states in the probable cause affidavit that that you had attempted suicide by ingesting pills. That's what they understood. Due to your condition, you were restrained in the hospital and sedated to receive the treatment. Apparently, when you woke up from sedation, then the assault that resulted in this occurred. But this says that you were in the hospital allegedly attempting suicide by ingesting pills, which it kind of contradicts other things. But what are we going to do here? Mr. Adams, I got a trial I got to go into here in a minute.
What's the decision? Do you want a 3-year cap or not? I would ask for probation. I have I didn't commit suicide.
No, you didn't commit suicide. But it was attempted. That's what it says. You attempted to do.
I got they put me in a helicopter to get there, and I don't remember any of that. I have severe PTSD for drowning, and they had that thing in my throat. I don't understand how I could hurt somebody when I'm.
Yeah, what do you want to do today?
So do you want the 3-year cap, or do you want to set it for trial? That's what the judge is asking.
Dr. Grapan has done the evaluations and all and deemed him to be competent and also that he is, right, he can move forward, but it's your call. If you don't have a decision, it just set it for trial.
Now, when I ask for the probation.
That's if you take the 3 year out, probation is an option up to 3 years.
Look, you need to talk to him some more. He doesn't sound like he understands really all of his options.
I talk with him again.
Yeah, I'm gonna give him a week to
That's fine.
figure this out, okay? All right.
You okay, bro?
What are you doing? You're shaking? Do you need some kind of medicine? Like Lindsay, do you need to take your medicine or something?
Ma'am.
Where is it? Where is the medicine? Does your wife have it?
It's in my vehicle.
Your vehicle? Okay. Here, we're gonna bring you, they're gonna sit you down.
Do we need to hear the court judge or take my son?
Okay.
Just take my son.
He says he's got his medicine in the vehicle?
No, sir, it's at the house. He's not going to take his estimate. Still so 12, he had to 8 o'clock. The last time he was in Jefferson County Jail, though, he wound up on life support. From
Why?
seizures.
What happened? On
They-
seizures?
Yes, sir. They were supposed to give him a certain kind of medication. You can only take the one. They didn't have it available. They wouldn't let me drop it off. And he wound up on life support in Baptist for 11 days.
So they wouldn't accept the medicine that he was prescribed? And
I had all the bottles and everything. They didn't take it. I wound up speaking to
somebody at the jail?
Major Guillory.
What'd they say?
She said if it was up to her, he wouldn't even have been there. She would have PR bonded him out, but she wasn't allowed to because it was an assault. But he actually wound up, he had like 11 back-to-back convulsions.
What's the medicine he's taking? Do you know?
Vimpat.
How much does he have to take?
He takes Vimpat twice a day. He takes glucosamide twice a day. And then
who is it that prescribed that? What
doctor? His doctor over here in Beaumont.
Who's that?
I can't, I'm nervous. I can't.
That's okay.
Can't think of her name. And I could get it.
What was his diagnosis? What did they diagnose him with?
He's got traumatic brain injury.
How did that occur?
He had a head-on collision somewhere.
From the wreck he was talking about?
Yes, sir. A young man hit him. Went on the.
When was that?
December 22.
Okay.
So since then, he's progressively got worse. He's got frontal temporal lobe damage. Sometimes the seizures are so bad, I've had to do CPR on him to save him.
Okay.
He goes into respiratory and then cardiac arrest.
Well, you need to take care of obviously his medicine so he gets stabilized. Dr. Rapon is evaluated. It says he's clear to go forward. So
medications that he was on that day, I was in the hospital.
Okay.
The medications he was on that day, when he was coming out of that off the life support, they had given him fentanyl, they had given him, and the medications he tried to commit suicide on are all prescribed medications. It wasn't straight medication.
Okay.
It wasn't straight drugs. It was.
Well, we're gonna bring him back in a week and see how he's doing and stabilize, and then we can talk about the options that I have, which can include probation and but if I put him on probation, it's gonna have to be really medically.
In the county.
Ma'am?
He is on probation in Angelina County.
For what?
Doing very well.
For what?
Deferred,
No, for what was the crime?
burglary of the habitat.
Well. Yeah.
They gave him the 10 years probation, which he's doing.
You can't be committing crimes.
4 years ago.
I know, but nonetheless.
I understand.
Yeah, he's
not
loading up on.
Consider that he was.
He's loading up on some problems, and if they put him on probation, if it gets revoked, I mean, if we put him on probation here, I mean, those can get revoked and then stacked on top of each other, and he's in prison for a long time. It's just we got to figure out what's.
Don't want to die.
Ma'am?
Don't want to. Don't want to die.
Yeah, we got, the medication or something.
He doesn't.
We need to get stabilized.
He can't drive anymore. He can't do anything. We have to take care of him all the time with the essentials. All the rest is always good.
But
He didn't.
But he's out in the public.
Remember anything that happened.
I know, but he's out in the public, and that's.
He's not out in the public without me. He can't go anywhere.
What happened in the probation office? Were you there?
When he assaults.
When he was in the probation office and taking his clothes off?
That's,
Well,
that
that
was
was something
my
about-
husband. It's the different, that was the first gentleman who saw.
Oh,
That's not.
sorry.
That was,
Sorry, I got
husband, my husband's clothes are on all the time.
Yeah, so.
Yeah, I know. I just said, I know.
But he's got medication that he's
He
been.
does, and I take him to all the
Do you ensure that he gets, that he
Absolutely.
takes, okay, that's important.
I'm a nurse myself and I take care of people.
I'm sure everybody's on. We're gonna just come back in a week.
Yes, well.
Let's try to figure out where. Somebody needs to reset him. Thank you.
Thank you.
David Grove on.
Ready and
So another messed up situation. You know, we talked about this yesterday a little bit on Sidebar, different circumstances, but people who are broken physically committing crimes, and seems like yet another example. So this is a live shot. Just to clarify this bus accident that I referenced a few minutes ago, and I said it was in Cleveland. This is Cleveland, Texas. So a smaller community, but what's super interesting or terrifying about it is apparently this is their second bus crash since school started just a few days ago. So they got to get their stuff together because that's not a good thing. So anyways, that's a live shot from there, so we know what's going on there. And I'll keep monitoring and keep everybody updated because all of a sudden I'm a quasi-news guy as well, it seems, lately. But that's okay. Let's go back to Judge Stevens.
Aggravated assault. And it looks like on the same date, it must be from the same event on or about February 26th, 2025 in Jefferson County, Texas.
That's correct.
And I guess 2 people were injured in the vehicle that was struck. You were facing a second-degree felony here in each case, which carries with it up to 20 years in prison. Also, you have a prior conviction in 2022. And if out of Ohio, and if that is a felony, it looks like it is a felony. If you were found guilty of this second-degree felony in either or both of these cases as alleged aggravated assault with a deadly weapon, then it gets enhanced 1 degree to a first-degree felony if that prior conviction is valid. And then you are now looking at the life in prison as a punishment range in this in this case, in these 2 cases. Do you understand what you're charged with and the punishment ranges that may be applicable?
Yes, sir.
They're serious. What are we going to do today, Megan?
Judge, I'd like a reset.
How much time do you need?
Probably a couple of weeks, although he has some medical
4 weeks,
history.
good?
Yes, sir.
Okay, we're set it for 4 weeks, okay?
And Judge,
Yes.
could we order him to be drug tested? He was on his jail calls asking for rehab to his mother, I think admitting to using illegal drugs on there.
Right now? Is that what you're asking?
Yes, sir.
Well, I got a jury I should have brought in 10 minutes ago for a trial, but have a seat right over there. And I'm going to pass you for that. Dylan Bouffleur, James. What are we doing on Mr. Bouffleur?
Thank you, Your Honor. Just this morning, I received notice that the Orange County DA's office has his file. They haven't filed a case over there. And the offer is if he'll take care of the Orange County case, they'll dismiss the Jefferson County case.
Okay, so what do you asking? Red delay, how long?
It's Orange County, I'd say 30 days.
6 weeks.
6 weeks.
Okay, reset 6 weeks. Thank you. Mr. McLemore,
Colin,
what are we doing on this one?
he's a plea, Your Honor.
Come on up, sir. My 24CR169 is now called. Colin McLemore, that you?
Yes, sir.
Present with Mr. Mayfinger, attorney and the state's attorney. Does the defendant waive formal reading of the indictment?
Yes, sir.
And the arraignment here to proceed in summary.
Yes, Your Honor.
In summary, this indictment alleges that on or about May 5th, 2023 in Jefferson County, Texas, You committed the third degree felony of operating a motor vehicle while intoxicated. As paragraph 2 goes on to allege that you have 2 or more prior DWI convictions, 96 in Hardin County, in 99 out of Jefferson County Court of Law, and then finally 2021, a felony here in this criminal district court. So paragraphs 1 and 2 constitute a third degree felony. Do you understand what you are charged with here, sir?
Yes, Your Honor.
If you're facing a third degree felony, that means you are looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, Your Honor.
An agreement has been entered in your case where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead in this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes, Your Honor.
And paragraph 2, which alleges those prior convictions of DWIs, 3 of them, are those true and correct as they are alleged?
Yes, Your Honor.
And are you pleading true and correct to paragraph 2 of this indictment of the prior convictions of DWIs voluntarily and because they are true as they are alleged?
Yes, Your Honor.
Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence, without objection admitted. Among other things, to state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You're giving up your rights to a fair trial and the rights to appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1, for the record for all purposes. Pre-sentence report is waived.
Yes,
I'm going to follow this agreement and find then you are pleading guilty and true respectively in paragraphs 1 and 2 to this indictment voluntarily, knowingly, intelligently. There is sufficient proofs supplementing your pleas of guilty to paragraph 1, the substantive offense, and true to paragraph 2, the allegation of 2 or more prior DWI convictions, to support this plea and find you guilty beyond a reasonable doubt of this third degree felony of operating a motor vehicle in a public place while intoxicated. I now find you guilty beyond a reasonable doubt of this indictment, this third degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Is there anything else?
Nothing further.
All right. You understand what has happened today, sir?
Yes, Your Honor.
Good luck to you. You will be taken into custody. Thank you.
Straight and put it on, get it out. Yeah, I'm gonna just tap it in the box.
John Laurie, Mr. Reynolds.
No, same.
Oh.
Tap it. Wait, one more.
25 CR 125. By the way, it's state and defense on this trial. I have the proposed jury instructions. Did you get copies of these? Okay. Yes, sir. Please review them. Thank you. What are we doing today?
Judge, he had a court lawyer.
Yeah.
Appearance, I was not here. Since the last appearance, he hired me. I understand that there was a bond condition placed on him that he have an ankle monitor.
Yeah.
At the last hearing, says he has one today.
Specifically, Judge, you ordered that he get it by the end of the day. Then you reset it for 2 weeks.
Do you have it?
Yes, sir. Yes, sir. I got it.
Okay. Okay. This is a state jail felony of theft, but he's got 1, 2, 3, 4 prior burglaries, of a habitation conviction in sequence. So this state jail felony, if all of this was proven true, we are looking at a state jail felony, though punished as though it were a second degree felony. That's right, up to 20 years in prison.
That's correct, Judge.
Okay, so what are we going to do today? What are we doing today? Announcement?
I think the hearing was set today to review to make sure he's complying with the bond conditions. Judge.
Is he?
Yeah. Yes.
Okay.
And I've just got the discovery and.
What do you want to do today?
Just if we could reset it for an announcement, let's ask.
It's 4 weeks good? Is it going to be now? Okay, reset 4 weeks for announcement. Thank you. Isaiah Hutchison.
I need to remove Mr. Reynolds from that, sir, and then I need to sign the receipt. Mr. Murchison, I need to fill out the work so I can give him a regular appointed attorney, one of our people.
That's all before the back record. We done with this.
Mr. Reynolds has been covered. They were linked together as the same person, so Mr. Reynolds.
One of them, Isaiah Murchison and the rest of your chart is related to this, the same. As Phil's charge against Jason for murder, which I represent Jason. I got appointed of Isaiah, so.
Okay, where's Isaiah?
He's in custody of baseball.
Do we need him out?
I don't.
No, he's not. He's not in our jail.
Down our jail. Isaiah Murchison. Isaiah Murchison is called in 25 CR 428. There is no answer in the courtroom. I ask the bailiff to call into the hall for Isaiah Murchison, please. Isaiah Murchison.
He made bond on June 20th.
I believe last time he was in court, Your Honor, he tested positive for drugs and the court revoked his bond, doubled, and then I believe he subsequently bonded out. That's correct.
Does he have a drug and a GPS device?
Yes, Your Honor.
We all know where he is.
Yes, sir.
Yep. Stuff. And I think we're trying to do that. So you're
contact.
Money or not.
And Your Honor, Mr. Reynolds was appointed to the defendant's brother, Jason Murchison, who's on a murder charge out of the same incident. And he has all of those cases. He's received all discovery on that. I'm guessing he's wanting somebody else to be appointed on.
Yeah, I don't think I can't.
On this one.
Yes.
Unfortunately, they language is the same.
Yes.
Bo, thank you so much for gifting 5 memberships. Very much appreciate that. Congratulations to our 5 new members. This community is great. You guys always rally to support each other, support me, and it's very much appreciated. So again, thank you, Bo.
In court. What's going on outside? You're supposed to be in here in the room.
The restaurant.
All right. You were charged here with the 3rd-degree felony of tampering or fabricating physical evidence here, which carries with it up to 10 years in prison. And you have a drug patch? Is that it? You have a GPS device on you? You're on house arrest. All right. And Mr. Reynolds has been your attorney?
Yes, sir.
But you got an issue.
I have a conflict because I also represent his brother, and I think the cases arose out of the same set of circumstances.
All right, you can't.
I think it'd be a conflict when we represent both of them.
Yeah. So,
I'd like to withdraw.
are you able to hire somebody? Are you able to hire an attorney? Is that no? You have to speak out.
No, sir.
Okay. Is there an indigent form here that he's filled out?
I need a new one, $50,000 bond.
Yeah, where'd you get the $50,000 to post a bond?
My mom worked.
Your mother's money.
Yeah, my grandma.
Your grandmother's money. You can't be proud of that. You gotta be self-sufficient. You gotta be self-reliant, independent. Look, I'm sure they need their money. How much income do you have? Do you have any income at all? Nothing, zero. Why aren't you doing something to make money? Why aren't you working somewhere? Are you a bum? I'm asking. When was the last time you had a job?
I'm working at McDonald's.
When?
January.
Sir?
In January.
Okay, what have you been doing to try to get a job?
Filling my applications.
Well, how many have you filled out?
Sir?
How many have you filled out?
7.
Here's what you're gonna have to do too, is I want a copy of every application that you fill out
Yes, sir.
from here on. And I'm gonna review this in 30 days, to see if you're working hard enough to get a job, okay? But there's a conflict, so I'm gonna find good cause that, in this case, Mr. Reynolds is going to be released. He can't represent both of you.
Yes, sir.
And another attorney will be appointed to represent you, and we'll get that information to you. Was this on the rotation or was this as a public defender?
It's on the rotation.
It shouldn't have been on the trial. It needs one of our people.
Are people on the rotation or on the rotation or on the public defender as a public? Okay. Then,
I believe Mr. Doozler was originally on there and then defendant requested.
you're
a
released,
trial.
buddy. And then the next person, and you get with this lady and
Yes,
she'll
sir.
help you out. Okay.
You say?
You said in 4 weeks. Yeah, he's got to get something to me. DeMarcus Roy.
Yes, sir.
Go see that lady. There, right there, right there.
Lindsay, thank you for gifting 10 memberships. You're always so supportive, and I really appreciate it. I appreciate all of you. And honestly, if you're lurking out there and you are new to the channel, Michael, thank you for gifting a membership. Very much appreciated. If you're lurking out there, you're new to the channel, this is the place to be. This is the best community in LawTube, and I'm not just saying that because it's the one I run. This is a good group of people. Hang out here. This is just the best place to be.
Add-ons. I don't.
She already did that one, Judge.
Jadarius Hamilton. I need Jadarius Hamilton, please.
Yesterday, the other day, he showed up. I told him he could come in this morning for the initials.
Ray Wise, are you around? Ray Wise?
Just to dismiss.
I see that. I just didn't know if he was here. Ray Wise? I have a dismissal in 25 CR 29, the state of Texas versus Ray Wise. Defendant pays restitution as required, and this case.
Barbara, thank you for gifting a membership. Again, this is the best place. And this just for the record, this isn't about the money to me. This is about the fact that these are people that want this community to grow because they believe so much in it. And that's the world right there. That means everything. So thank you so much.
Thank you. Are you Jadarius Hamilton? Come on up quickly. Oh, we got to get back into a trial. You were charged. Stand right over there. Oh, yes, yes. You were charged in 25 CR 769 with the state jail felony of criminal mischief, carries with it up to 2 years in the state jail. Are you getting a lawyer?
Yes, sir.
So who?
Oh, I'm no closer.
Why? Why do we have to pay for you? The taxpayers. They're not free. You go hire if you're in a mess, you get out of your mess by acting responsibly, and you go hire your own lawyer. That's what we do.
I mean, it's my first time, so I don't know how.
Okay, that's the way it works. You get in trouble. It's just, we don't print money here.
I'm no problem, sir.
Yeah, we don't print money. Yeah, and the taxpayers pay for a court-appointed attorneys, but
I still paid for a court-appointed attorney. I thought it still came out of my pocket.
yeah, that's what you go. You go just like like most people, if you can afford it, you go hire your lawyer.
Okay.
Where are you working?
Back to.
What do you, how much do you make an hour there?
20.
Okay, yeah, you go hire your lawyer.
Okay.
I'm gonna give you 4 weeks to talk to some people.
Right. You have some references I can,
And here, we're gonna get you a resetting. If you hire somebody, give that to them so they can make a copy so they know when they have to be here to represent you.
Yes,
Yeah.
sir.
And if you can't find anybody, you come on back and then we'll work, we'll see what the deal is and try to help you out.
Right. What about, I go through a bunch of them, what do you mean can't find one? Like, it's the
Well,
price
if
of
you
money.
can't hire one, come on, you gotta come back in 4 weeks and then we'll pick it up from there.
Okay.
We'll
But
figure
try to
out
find
where
one.
you are, what's the deal, and, but you're making enough money to hire somebody, and then they work with you over time. Sometimes you have to pay over in installments for the lawyer, you know? But here's the deal, is they're your lifeline, when you're looking at, 2 years in the state jail, so.
Myself home. So if I don't find one,
come back,
and then what?
On that day.
What about, I'm talking about the far as the 2 years in jail, like how do you get there?
Oh, no, don't worry about
back,
that. No, you're right now presumed innocent of a crime.
Okay.
That's the way it works. You're charged, so you got to deal with it. And you don't want to get convicted. That's the important thing. You've never been convicted of an offense before. You don't want to, especially a felony.
No warrant either, but I almost had one today.
Oh, really?
My bail bondsman didn't tell me that I had court. They still haven't told me, but
Really?
Jefferson County has.
Okay, well, we're not revoking his bond.
I understand that, but that's just bad. They didn't tell me, so now I'm at work and I'm in the car like, you missed courtroom. I'm supposed to know that my bail bondsman didn't get me. I call them. They don't know either. I'm supposed to be calling my bail bondsman.
Well, that's what you paid them for.
I know what's, how does that,
I can't control.
I understand that.
Okay.
Could you lace me up, please? No, I don't.
Yeah.
It's exactly 3 miles.
Sometimes they make mistakes.
I told them how to check our website now for every
not
court
that, it's
hearing.
not
Did you lose money or something today?
I don't know. Yeah.
Okay, if you did, you talk to your bondsman and let me know if there's an issue. Because if they make a mistake, they pay for their mistakes.
Okay, so.
It's all been worked out, Judge. He just needs to find the reset.
I know,
Get
he's
sloppy at it.
I think he's more worried about if he loses money or something
Not
from
even
work.
that, like,
I think he was pretty.
say I don't get a notice. I never know. I get a warrant out. Now I'm screwed,
No, you're not.
I could be screwed. Say I didn't come today.
No, we're gonna fix you.
I understand that, but it falls back on them, so I'm getting it. That's
Sir?
bad.
You're gonna
It
get-
falls back on them is what I'm getting at.
Yeah, yeah,
He's resetting
I know. We can't undo the mess,
I understand.
but we can keep you from being hurt. And that's what we're gonna do.
I know that now.
Judge, yeah.
So Bailey, thank you for gifting 5 memberships. Bo, thank you for gifting another 5. You guys are just amazing. We're up to 27 gifted memberships today. The record is the mirror of that. 72 is the most we've done in one day. So interesting. But again, you guys are just the best. I'm always amazed by how much you guys care about what we have here. It never ceases to just blow me away. And Ashley throws 10 down. Thank you, Ashley. Yeah, we just might break the 72 at the rate we're going. You guys are something. Let's go back to Wade Mercer in Florida.
There was the allegation against you, and that was Tommy Blizzard. So now you're accused of the same charges plus an additional charge. You're accused of one count of prohibition against giving false information, which is a new charge. That's a third-degree felony. Then you have the same charges you were accused of yesterday under your brother's name, which are driving while license suspended, possession of methamphetamine. I set your bond on those cases, I believe, correct, Don? Thinking that you were your brother and you allowed that to take place. Obviously, that's allegedly giving false information, not only to the officer, to the jail, but also to the court. So what I'm going to do is tell you now that we've got your correct name, you have a fugitive warrant from the state of Alabama, from Houston County. So you'll deal with that later. I'm revoking the bond I set for you yesterday based upon your apparent or alleged falsehood to the court. So you've got no bond from yesterday. Your new bond of prohibition of giving false information will be a $25,000 bond. So some of your cases have no bond. One case has a bond, and you've got a hold from Alabama to deal with in the future. Everything's going to be in felony court, and you'll be seeing the felony judge sometime in the near future. Mr. Blizzard, do you have any questions?
No, sir.
Wish you the best, sir.
Well, what was this case number in the one from yesterday? John mentioned it.
We don't have that. I don't. Yeah, we don't. You can find it in the clerk system. We don't have that.
All right. And its new bond was 2,500.
25,000.
25,000.
Because it's a felony charge. And wish you the best, Mr. Blizzard. All right. So your client, actually not your client, Mr. Edwards. The defendant in your case is outside talking with his attorney, but Mr. McDaniel knows that you're kind of in the time crunch, so we'll come back to that as soon as they get back inside.
Yes, sir. No
We
worries.
have Mr. Turner on the line. And Mr. Turner, do you have a case at the jail, sir?
Yes, sir. I believe I have Coleman Tillman.
Let's jump over to that case. Mr. Tillman, Coleman Tillman. Let me find it on my docket here. It's Jackson County case 24-109 MM. Mr. Tillman, good morning. Mr. Tillman, your attorney, Mr. Turner, is appearing remotely to listen to Mr. Turner, Mr. Tillman, and we're going to see where we stand in your case.
Yes, sir.
Thank you, Your Honor. Mr. Tillman, I've spoken to your family. We were not able to get together the verifications of the AA classes. So at this point, I would recommend to you that you accept the court's 90-day offer with my understanding that you'd receive credit from when you bonded out in Calhoun County, which was July 31st. So I count that at 14 days credit.
I counted.
Mr. Tillman, Mr. Turner, the jail notes that I have say 48 days credit, but now that you may have 14 from this time, but I think he must have some jail time from the original charge. We get 48 from somewhere. Where's the 48 come from on the list? Does anyone know? Mr. Mitchell, is that your notes?
Yeah, that's my notes right there. I think it was time that he was in jail prior to picking up the Calhoun County charge and time he was in Calhoun County, which was only like 20 something days.
He doesn't get, and this was the email that I exchanged with you and Mr. Turner. Correct. Specifically, I would not give him credit for time he was there on the Calhoun County charge. Mr. Turner did the research and he agreed. So have you then gone and give him credit that I've already told you I would not give him?
That was my mistake right there.
That's a big mistake because that email is very clear.
That's my mistake right there. So it's 14 days.
So, Mr. Turner, you researched this issue and your email back said that you agreed that he was not entitled to that credit in Calhoun County because he was serving a sentence down there. Is that correct, Mr. Turner?
It wasn't because he was serving a sentence, but he was being held on new law violations there. So the case law I found indicated that if he was being held on new law violations there, he was not legally entitled to that credit. But he did post bond on July 31st. I do believe he's entitled to credit from there, even though he didn't get to Jackson County till the 1st.
So your calculations are 14 days credit, right?
Yes, Your Honor.
First time on this case also. Okay, Mr. Turner, Mr. McDaniel thinks he may have more than that because if he was arrested initially on this charge. Mr. Turner, does your 14 days include the pre-probation time?
No, Your Honor, it does not.
Okay. Corporal Drown at the jail, do you show any pre-probation time? I can probably look it up. It's probably a few days, or Mr. Tillman may remember how long he was in jail before.
I believe it was 4 days.
Mr. Mitchell, any objection to 4 additional days in addition to the 14?
No objection.
18 days credit, Mr. Turner, you okay with that?
Yes, Your Honor.
Okay, so Mr. Tillman, if you decide to enter this plea, the tentative agreement is 90 days in jail with 18 days credit and any remaining court costs and fines of
360.
360 would be ordered because that's what was originally ordered. That's what's left of what was originally ordered. Mr. Tillman, you do not have to take the offer, but if you want to, you can do that. If you would rather set this matter for a VOP hearing, then we can do that also. Any questions, Mr. Tillman?
Yes, could I have a meeting with my attorney, in private before I make any decisions on and still possibly accept this offer?
Absolutely. So, Mr. Turner, I think that was going to happen before today. For whatever reason, that didn't happen.
I did
Mr.
meet with
Turner,
him last week,
he
Your
obviously
Honor.
wants to meet with you.
Sure.
I'm
And
sorry. I gathered from your initial comments you were not able to speak with him. But what's your suggestion, Mr. Turner, as far as scheduling? You want to set him for next month and then bring him up at first appearance if we get something resolved before then, or do you want to do something different?
We can do that, but Mr. Tillman, it's going to be next week before I can get to the Jackson County Jail to see you. So as long as you understand that,
okay.
I'm fine with that.
Yeah, yes, sir. You have a idea of what day possibly next week?
Probably Wednesday.
All right, Madam Clerk, what is the private attorney docket date, our next private attorney date?
September 11th.
September 11th?
Yes.
9/11.
I know. I said it to Brian Kelly yesterday. I was like,
So, September 11th, Mr. Turner?
All right, Judge. And if we get something resolved, we can get on one of your morning dockets.
Absolutely. First appearance, just about every day I'm here, almost every day. So, Mr. Tillman, we're going to schedule you for September the 11th. That docket will be at 9 a.m. No, that docket is at 1:30 p.m. But Mr. Turner, after speaking with you, certainly can call my office and coordinate with Mr. Mitchell's office and bring you up at first appearance one day after y'all meet and you get your questions answered. The clerk has a question. Yes, ma'am.
You don't normally connect to the jails and room on that day.
Okay, so we will have to that day, though. Actually, or we could put it on the day that we have the jail arraignments, which would be when?
the day before.
Okay, Mr. Turner, September 10th, okay? That's probably better for our technological issues.
Yes, Your Honor.
September 10th, unless I see you before then, Mr. Tillman. Any questions?
no, sir.
Wish you the best, sir.
That would be it.
And that's at 9 a.m. Okay, so then we need to jump over to Mr. Edwards' case. Let me get that pulled up on my computer here. The State of Florida versus Walter Harrison Bassford 25-138 MM. Is that right? Is the MM case number?
Possession. Possession.
Okay, so it's one charge of DUI, property damage with personal injury, one charge of alcohol possession by a minor. We have Mr. McLean Edwards, Assistant State Attorney out of the Second Circuit. Is that right, Mr. Edwards?
Yes, sir.
Here on behalf of the state, we have Mr. McDaniel on behalf of the defendant, Mr. Bassford. And Mr. McDaniel, where do we stand in this case? Your Honor, we had this case set for trial. I've talked with Mr. Bassford. I've let him know my thought process was let's just go to trial. It's ultimately his decision though, and he's made a decision that he just wants to go ahead and resolve this case today, Your Honor. So we're just going to enter a plea of no contest. And this is, it's not against my advice, but it's not, my advice was actually just go to trial. But at this point in time, he wants to enter a plea of no contest to the charges as listed. And we're just I went over with the maximum sentences that could be imposed. And he's just going to ask the court for leniency and ask the court for sentencing. Mr. Bassford, let me get you to raise your right hand, please. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but truth to help you God?
Yes.
Okay, Mr. Bassford, you understand in this case, you're accused of 2 charges and you have the right to go to trial on those charges. If you're let to go to trial, then what's going to happen is we're going to pick a jury. I think it's set for next week, Mr. McDaniel.
Yes, sir.
And that you get a chance at the trial, you have be represented by counsel and get a chance to call and cross-examine witnesses and present your side of the case and even testify if you wish to do so. Do you understand all of that?
Yes, sir.
If you enter this plea, there will not be a trial. That case is over. There won't be a trial. You get to call and cross-examine witnesses. All of that will be waived. You're waiving all those rights and forfeiting the right to go to trial, which the Constitution guarantees you. Do you understand that?
Yes, sir.
In exchange for that, if you do that, I'm going to listen to you. I'm going to listen to Mr. Edwards. I'm going to make a decision that I think is fair and appropriate.
Okay.
And as you know, I'm going to try to be consistent with what I've done in similar cases in the past with individuals who have similar criminal history and similar charges. You understand all that?
Yes, sir.
And is that what you want to do? You want to enter a plea of no contest to these charges and waive the right to a trial and your other rights associated with the trial. Is that correct?
Yes, sir.
Okay. I want to accept the plea of no contest to the charges in case number 25-138 MM, driving under the influence, causing or contributing to injury to person or property, and possession of alcohol by a person under 21 years of age. So let me hear from Mr. Edwards first on the state's recommended disposition, and then I'll be glad to hear from you, Mr. McDaniel.
So Judge, I will just, first thing I'll ask, have you had a chance to review the probable cause affidavit?
I did either at the time of the original arrest or a prior pretrial date, and I'm aware of the significant, unusually high breathalyzer, especially when coupled with Mr. Bassford's age. I think it was a 0.32.
0.35. There were
Yeah,
two separate,
and
two
Mr.
separate,
Edwards, and being in, no, it's okay. I think I interrupted you, but in being in the criminal justice system for 30 years, that is the highest breathalyzer I have ever seen for someone of his age. Now, I've seen higher breathalyzers, but not for Mr. Bassford's age, which is about 20.
At the time, yes, sir.
I've never seen a breathalyzer that high with a 20-year-old. So that is what it is, Mr. Edwards.
yes, sir. And that's the state's concern as well. I understand that, you know, Mr. Bassford is a young man, and I'm not going to ask that you sentence him to jail, but you know, we got to have something that is going to protect the community as it relates to knowing whether or not he is driving under the influence. Really, the big stick in this case was whether or not the ignition interlock device would be imposed. I'm asking the court to do that. It appears that, you know, that's about the best shot that we got. I believe that Mr. Bassford will, you know, turn his life around, will change his ways, but I think that the ignition interlock device is going to do that. So I'd ask that you just do the standard minimum DUI requirements, including the ignition interlock device.
Thank you, Mr. Edwards. Mr. McDaniel.
Your Honor, I mean, I don't disagree with anything that the prosecutor's saying. It is a, you know, unfortunate thing going on. I will say for Mr. Bassford, though, as far as the interlock, I think that's the only issue we're talking about, really. I think I agree with everything else. The interlock is that essentially, Your Honor, he has voluntarily went on medications that won't allow him to drink alcohol. And he will get real sick if he drinks alcohol. And we have no issue if the court wants to even make that part of probation that he has to continue to take that medication, you know, that he's taken, so that he can't consume it. This is something his parents did to him. And he's on that medications now. I know it's making him a little bit shaky at times. But you know, our intent is, you know, is hopefully the court will not do that, because, you know, the interlock gets kind of expensive. If it gets on his driving record, you know, obviously his insurance rates and things like that, you know, which his parents are essentially taking. And I think that the medication is on is going to, you know, satisfy, I think, the prosecutor's concerns about him, you know, driving, as long as he's taking the medications. And, you know, I've no doubt the parents are going to be watching him, make sure he takes the medications, and he voluntarily wanted to take the medication. This is something that's not a court order. I mean, this is something they did on their own. So, and I know he don't, you know, I know they don't know about that. The prosecutor doesn't know about that. So and I hadn't even spoken to him about it, but just want to let him be aware of that also.
What is the medication?
What's it called? Antacid, I think. What is it called?
I don't know the scientific term for it. It's basically antabuse.
Is it Vivitrol?
Does Vivitrol ring a bell? Is it administered through a physician?
Yes.
Is it a shot? Is it daily or weekly or monthly? Daily pill he takes. It sounds like antabuse. And it's one that Mr. Bassford, the other Mr. Bassford, Captain Bassford, that way it's clear who I'm talking to. That is one that y'all make sure he takes it home, or does he have to go somewhere to take it?
No, takes it home. I have it.
But it's a prescription medication. So it says it's prescribed by a physician. Okay. So that's one issue. The second issue is the what's the device the state's asking for? The interlock device. So Mr. Goodson, well, first of all, the interlock device is required by statute in certain cases, but not in this case. Is that accurate, Mr. McDaniel? Or is it a condition required by probation, or is it a condition required by DHS&V to get the license back?
It could be both. Here, I think we're just asking it through probation, I think, but it could be both. I mean, DMV could force him to do it. I don't know if they will or not, but they could.
So here's my question. Since he's not pleading to over 0.15, will DHS&V compel him to do that?
Not to my knowledge.
Okay, so Mr. Edwards, any questions about that? Any input?
So while I understand that, and I'll be honest with the court. I mean, I didn't file the information in this case. He is charged with a first degree misdemeanor. It's my understanding over 0.15 is just a second degree misdemeanor. That being said, the reason that the law requires it when the state chooses to charge over 0.15 is because of the concern. And again, I appreciate knowing that he's taking this medication. That's great. That's not to say that people who have drinking problems won't fall off the wagon and commit to drinking again. Now, I understand it may make him sick, but that's of even greater concern. So I would, while it's not mandated to the court, I think ultimately the facts in this case lend to requiring. So that's the state's position.
Okay, thank you. So, Mr. Goodson, with the probation office, here's my question. Traditionally, we've not done that device in Jackson County for two reasons. The number one is the expense of the device, and secondly, the availability of the installation of the device and the calibration.
Yes,
Now, DHS&V may require it to get the license back, but typically it's not a condition of probation, regardless of the breathalyzer. So, make sure I'm on the same page with the probation on that.
And for clarification purposes, before I answer that, he's entering a plea to DUI less than 1.5. Is that correct?
That's what he's charged with. He's charged with.
Okay.
He was the state before Mr. Edwards was on the case. The local state attorney's office filed the information.
Okay.
And the information filed in the case, which is what I was reading from earlier, is 0.08 or higher. It's not 0.15 or higher.
Okay.
So he's
just a standard DUI.
No, he's pleading to a DUI with property damage, personal property damage.
Okay.
So it's a first degree misdemeanor, which is actually a higher degree crime than 0.15, but it doesn't have, I don't know that DHS&V will make him do the interlock device because he's not pleading over 0.15.
Okay. So my understanding of the law is if he's pleading to DUI with property damage less than 0.15, even though the breathalyzer results were higher than that, that he would not have to, now, I don't make the decision totally for the Department of Motor Vehicles, but previously of all the individuals that have pled to the same similar charge, they did not have to have the interlock.
Okay. So what's the problem? What is it still the same situation we've had here? The availability and the cost. You know anything about the availability of the device in rural counties and the cost of the device?
My understanding is my dealings with interlock, they have to go to Panama City once a month. There's $120 to $150 cost to have the device calibrated once a month in Panama City.
Is there a monthly that's the $120 per month every month as long as he has a device?
Yes, sir.
Okay. So Mr. Edwards, that's why I don't know that I've ever done that. Okay, so I'm not likely to do that because of the cost. Because he's already got probation fees and the DUI school. DUI school itself costs several $100s. The counseling costs, they just become so financially prohibitive that it's almost impossible. Having said that, it's not impossible, but you're just adding insult to injury. So Mr. Edwards, I'm unlikely to do that. But given the extremely high breathalyzer, I do want to give you a chance to know, now that you know I'm unlikely to do that, are there other conditions other than the antabuse that you think would be reasonable that I certainly will consider given the extremely high BAC and Mr. Basford's age? If there's something else that you think will help, I'm the same position you're in. I don't want to see Mr. Basford again in court. And if I see him in court on a VOP, I think everyone here knows what's likely to happen. You know what's likely to happen, Mr. Basford. What's that?
Go to jail.
Yeah, and stay there
Yes.
for a while.
Yes.
So I don't want that to happen. So if there's other conditions that the state is requesting, I'll certainly consider them and give Mr. McDaniel a chance to be heard on those. Mr. Edwards.
Yes, sir. So a couple of options.
Let me interrupt you for just a second. I mean, I'm thinking curfew. I'm thinking if there's something else that will help him be a success other than the antabuse, and I want to consider that. Go ahead, please.
No, I think the curfew would be fantastic. Some of the options that we have here in Gadsden County, and of course they contract out because we're a pretty poor county. It's not like the county can afford to have all these devices for probation, but it's we have basically portable systems. There's the Scram unit, which attaches to the person's leg, and it basically monitors the alcohol in their body at all times. Those are different options. It's my understanding that that's not something that Jackson County has normally done. I am sure that they do it in Bay County, but it may be a similar situation where, he has to go get it calibrated in Bay County. Those are options. I think a curfew would be an excellent idea, but at the end of the day, that's kind of the ignition interlock is where I always came back to, was because it's just something that is in the statutes, and it's a lot more common than the scram or what they call the BART unit, or just random alcohol testing, urine testing would be an option too. But I'm not sure that Jackson County has that ability either. So
we do have random urine testing, but in checking on that with Mr. Goodson on other cases, the problem is I don't know how recent it'll determine alcohol use. The testing we have, Mr. Goodson, what's the deal with urine testing or alcohol testing?
Of course, immediate results would be a breathalyzer.
Okay.
But my understanding through True Care Labs is they do test for alcohol. There's nothing immediately. They can give a blood test, but they have to send it off. In my understanding, the cost is around $250. So I've been told. They don't have an immediate test. Mr. Edwards, we use a True Care Lab drug testing facility for all our probationers, which I'm sure there's a True Care Lab in Tallahassee. So that's my understanding based on what I've been told. The Marion office does not do that. The Tallahassee office does do that. I will say that Mr. Bashford has been on conditional release, Judge. He's already completed the level 1 DUI school. He was referred to aftercare counseling. So he went to DUI school for the 16 hours of class and the evaluation. The evaluator ordered him into the mandatory aftercare counseling that is required by the DUI school. I confirmed yesterday through Dr. Spires' office. There's 2 providers here, Dr. Spires and CARE. They have to be a certified provider through the DUI school. I received a completion certificate almost a week and a half ago from Dr. Spires that he had completed the aftercare program. My understanding, per Dr. Spires in the DUI school, the aftercare program is 12 hours of class, 12 sessions. So he has completed the DUI school. He has completed the aftercare counseling that was ordered to him by the evaluator at the DUI school.
There was a note in your file when I looked at it yesterday. There's an allegation that he had consumed alcohol on conditional release, but when he was confronted, there was no one to testify to that, and he denied that. There was no evidence that he had no admissible evidence that he had done that, correct?
Yes, sir.
Okay. All right. So, Mr. Bashford in the audience, let me look at this was at 9:07 p.m. Usually I wouldn't do a curfew on a DUI, but as I've said, I've never seen a 20-year-old with this high breathalyzer. Would a curfew be helpful from the parent's perspective in this case?
Judge, we're open to a curfew. I can tell you, he's not a person that's out late at night. The curfew being a condition makes no difference to us. He started fire school or went to orientation Monday, class started. This coming Monday,
Okay. Could you hear that answer, Mr. Edwards?
I just heard that he's open to it. He's in fire school. Is that correct?
He said he started fire school Monday. So, Mr. Bashford, what is the schedule with your school then?
8 to 5 Monday through Thursday.
Okay. All right. So, Mr. McDaniel, any further input from you or Mr. Bashford on the conditions of probation?
I don't think I have anything additional. Whatever the court thinks that would be helpful for him and for the family, we're acceptable to.
All right. So, Mr. Bashford, what I'm going to do is I've already accepted your plea of no contest to these 2 charges. I'm going to adjudicate you guilty, which I have to under state law. I actually have to adjudicate you guilty to DUI. I withhold adjudication of guilt on the second count. That second charge is a second-degree misdemeanor, correct? So, the DUI, I'm going to sentence you to 11 months and 29 days probation. You'll have the standard conditions of probation, Mr. Bashford, plus you'll have the following special conditions, the special conditions, most of which are required by state law. They are court costs and fines, in the amount of $1,078, 50 hours of community service. Successfully complete DUI school, successfully complete counseling at least twice a week based upon the breathalyzer. Twice a week equates to 24 sessions. If you've already done the DUI school, that's 16 hours. If you've already done the follow-up, you probably have already done the 24 hours that I would make you do. I'm not going to make you do more than I'd make anybody else do. Because Mr. Goodson, from what you said, he's done more than 24 hours between the DUI school and the follow-up counseling he had to do, correct? Okay, as another special condition of probation, I'm required that you take as directed the prescribed medication and abuse or the current medication. I'm going to require you within 1 week to get documentation from your physician of the exact medication it is. So it's your responsibility to get that to him within 1 week, and it's your responsibility to take it as prescribed by the physician. So it's no longer voluntary effective today. It's mandatory. I like the idea of a curfew. I don't know if it's going to help or not. I intend to put a curfew on you of 10 p.m. until what time do you have to leave for school or work?
Leave at 7, I guess.
Are you still working some in the cattle operations? What time do you leave on those days?
5 o'clock.
Okay, 4 a.m. From 10 p.m. to 4 a.m. You're going to be at your residence. I'm not going to impose any other devices due to cost reasons. I like the idea of the scram unit. I just don't know anything about it. Mr. Guston, I'd like for you to look into that because in these really high breathalyzer cases, that would be something I would like to know more about. The main question I would have is it cost prohibitive, especially for a young person to pay?
We did, at one time, Judge Jackson had initiated that program, lasted about 3 months, just for something back. But that was 15 years ago. I'm sure it's probably advanced now. They used to have to come in. Anyway, I'll check on this.
The other thing is I'm unlikely to grant early termination in Mr. Basford's case because of the extremely high breathalyzer. It's possible. I'm not saying I won't. I'm just saying I will look at the situation and see how you've done at 6 months. It's not going to be an automatic early termination. Your breathalyzer is extremely high.
Yes.
So Mr. Basford, I've known you since you were a child.
Yes, sir.
I probably went and saw you at the hospital. I want you to get off this probation.
Yes.
But if you get caught drinking and there's substantial, credible evidence that you violated your probation by consuming alcohol or possessing alcohol or any other way, I will run to the computer to sign a warrant.
Okay.
Because I'm convinced that may save your life
Yes, sir.
or save someone else's life.
Yes, sir.
I'm convinced of that. I'm convinced if you don't quit drinking, you're going to kill yourself or you're going to kill somebody else. That's as clear as I can make it.
Yes, sir.
And hopefully you've quit.
Yes.
I hope that's true. What other standard conditions required by statute have I missed? I'm going to recommend the minimum driver's license suspension. I'm sure that Mr. McDaniel's already explained that to you. There may be another suspension that takes effect now, but if you've already got your work permit, there's a process you can go through. Mr. Goodson will help you with to reapply for a business permit. That's pretty standard. You've already got your business permit,
Yes,
correct?
Yes.
So there's a process you got to go through to get it, to try to get it again, because Florida law causes another suspension to start today, right, Mr. McDaniel?
Yes, sir.
Mr. Goodson, have I missed any other standard conditions, Madam Clerk?
Clarification. So he's going to be on probation for 11 months, 29 days on DUI and 6 months on the possession.
Thank you. Thank you for clarifying that. The second counts a second degree misdemeanor at 6 months probation concurrent, no additional court costs and fines.
Your Honor, the only thing we would request is that, the fine, we give him that opportunity. He's 20 years old in college to work at Public Works or something, minimum at $15 an hour to pay off the fines if he so chooses. Now, he does work on the side and stuff. He may choose just to pay it off, but, I don't want the father to have to be set with having to pay this amount, making good work if he's can't pay it.
Mr. Edwards, any objection to that?
No, sir.
I'd allow that in every case. If you want to do the fines or some portion of the fines, community service, you'll be given a chance to do that. We use $15 an hour because that's going to be minimum wage in the very near future in the state of Florida. Ms. Williams, anything else?
For me, because the information is filed to a point or higher, we have the breathalyzer in as what it was submitted to us as. We have not altered that. So is this lead to a less than 0.15 or is this just going by the information?
This is going by the information. That's what Mr. Basford's office charged him with. Mr. Edwards has not filed amended information. He's entering a plea to how he was charged at the time by the prosecutor's office that was involved at the time. When I say Mr. Bassford, I know that's very confusing because the head prosecutor is Mr. Larry Bassford. So his office filed the information and that's what he's entering a plea to. Is that right, Mr. McDaniel?
Correct.
Okay. So, anything else? Any other questions? I know it's a little confusing. So the bottom line is don't be drinking, get everything done, stay out of trouble, but you've never had a problem staying out of trouble your whole life until the last 6 or 8 months. It's kind of snowballed on you. There's some civil infractions. Before I get to those, Mr. Edwards, anything else from the state on the criminal case, sir?
No, sir. I appreciate y'all and it was good to meet y'all.
Thank you, Mr. Edwards, for covering this case. Sorry for making you run a little late. Hopefully you'll get over there in time for your family funeral. And I'm sorry for your family's loss. Thank you, sir.
Mr. McClain, thank you very much. I'm sorry, go ahead.
Can I say something, Mr.
Mr. McClain, thank you very much. It was great working with you, John McDaniel, and I hope to talk to you again soon, sir.
Yes, sir. Sounds good.
Mr. Mitchell.
And Mr. Edwards, I just wanted to let you know Megan People says hi.
Hello to Megan. All right.
Thank you, Mr. Edwards. Okay, so Mr. Bassford, thank you, sir. Mr. Bassford, you also have 3 civil infractions: stopping or standing or parking on a highway, careless driving, and open container. Mr. Bassford, when I have someone that has a DUI and they have civil infractions, if the person wants to resolve the civil infractions, I typically withhold the court costs and fines and waive the points on those. The reason I do that is because you've already got over $1,000. It's probably well over $2,000 by the time you figure all the counseling and everything. It's probably going to be over $2,500. This is going to cost you or your family before it's all said and done. So if you wish to plead no contest to those civil infractions, I'm going to waive the court costs and fines on those, waive the points. You don't have to. You can go to a hearing on those if you wish. Do you want to resolve those while you're here today by pleading no contest?
Yes, sir.
Show a plea of no contest. Those 3 civil infractions: 25, 726, 724, 722 TR. Withhold adjudication of guilt, waive the court costs and fines in those cases. I think that's everything. Let me look at this disposition and make sure I haven't missed anything. I think that's it. Mr. Bassford, I wish you the best. What I'm going to do is give you some paperwork. We're going to get you to see Mr. Goodson with the probation office. Mr. Goodson, if he has any significant violation, any willful and substantial violation, I need to know immediately of that violation. All right. So, Mr. Bassford, see Mr. Goodson. I wish you the best, sir. So I know we're on the jail connection still. Unless someone needs this connection, we're just going to stay on it. They don't need it in circuit court, do they?
You got the pretrials of jail.
Okay. That was my next question. Do we have some?
All right, friends, we're going to go to see our buddies in Louisiana in just a moment. But before we go there, I did want to take a moment and talk about the sponsor of this channel and the sponsor of today's live show. And you guys all know that's Aura, because I've been talking about them for a few weeks, and I've been talking about them for good reason. Number one, that's a big company that was kind enough to partner with this channel, and that's something worthwhile. But beyond that, I asked them when they reached out to me to prove what they could do, and I took a while to make them prove it, and they have. So you guys know, because you've heard me talk about it, that they, in my opinion, are the best all-in-one solution for protecting yourself online as far as your data and your privacy go, all of that sort of thing. But it never ceases to amaze me just the kind of things that they find. So I wanted to share a screenshot with you. This is compliments of Bailey, and he said I could use his name and use this screenshot. But Bailey has signed up for Aura, and he's only been with them for a few days. And as you can see, they've already found and completed 42 different removals of his data. So 42 different places. They're working on 13 others right now. And I think Bailey would probably agree with me. The majority of the companies where they're removing your information from, you don't even know they exist. I went through my list and I had no idea who half of these companies were, and I'm willing to bet Bailey would say the same thing. Now, this is my screenshot as of this morning. 43 requests completed. They're working on 15 others. And of that 43, I've kind of gone into whack-a-mole mode with it now, where they're doing like second requests, because what happens over time, unfortunately, is they'll request the removal of that information, but then it'll pop back up. But Aura, once they spot it, continues to monitor those places where that data is, and will continue to work on it for you. So bottom line, your stuff's out there. It's not good for you. It's not good for your safety. And they're the ones to take care of it for you. Not only do they have the monitoring of your data and the removal of it, but they're also great, in my opinion, for spam calls. I've mentioned before, I would have 10, 12 spam calls a day. I'm down to maybe one now. They've got VPN and antivirus, parental controls. They've got a great password manager, a lot of things that can help you out. So it really becomes a one-stop shop. And as I've said before, if you go through aura.com/TCF, you're going to get 2 weeks for free. So you have absolutely nothing to lose. If you're on the fence on this one, today is the time to get off of the fence. Sign up for them. You'll find out within 24 hours what they'll be able to do for you. And within those 2 weeks, you'll see them take action on the things that they find. So it is totally worthwhile. Again, aura.com/TCF. Give them a try. Get off the fence if you're on it. And quite honestly, not only support the people who support the channel, but help yourself. It does make a difference. And if you think I'm lying, just ask Bailey. He sent a screenshot and said, hey, you need to share this. So I did. All right, friends, let's go to Louisiana. Let's see what's up with the parole board.
Good morning. The Committee on Parole reconvening. We're now in Orleans Parish at 9:06 a.m. on Wednesday, August 13th. My name is Cheryl Manazza, serving as chairman today. My colleagues on the panel are Mrs. Ledoux to my left, Mr. Barra to my right. And this is Mr. Smith.
Yeah, yes, ma'am, it is.
Mr. Smith, do you have an officer in the room with you?
Yes, ma'am.
I'd like the officer to introduce themselves for the record.
Good morning. I'm Alicia.
Yes, ma'am. Thank you for accommodating us this morning.
Thank you.
And Mr. Smith, tell us your name and DOC number, please.
Eric Smith, 468-213.
And I see you have your counsel. Counsel, would you introduce yourself for the record, sir?
Good morning. My name is Alex Bello, representing Mr. Eric Smith.
Okay. And are you retained counsel, Mr. Bello?
I am retained counsel.
All right. Thank you, sir. We appreciate you.
But for clarity, he retained. I was not appointed to represent him, but I am doing this pro bono, just for clarity.
Okay. Well, thank you, sir. So it's my understanding that Mr. Smith appeared before a parole panel last week on August 7th for a revocation decision.
Correct.
At that time,
You froze. We're frozen. Hello?
Isn't it amazing that the Ellie pop-up was it's a Zoom world, we're just buffering in it, comes on at that very moment. I did not do that. Those are on a random schedule. That was hilarious. Well, we'll just hang.
all right,
there we go.
I think we've resolved. Can you hear? So I was saying that Mr. Smith appeared before a parole panel last week on August 7th for a revocation decision. And at that time, that panel voted to terminate Mr. Smith unsatisfactorily because it appeared at that time that his full term date had passed. That was an error on the time calculation. And so that decision was rescinded August the 11th based on the error in the time calculation. So that's why we're here today, is to reconsider the revocation process.
Yes,
so you have retained counsel this morning, Mr. Smith. So I'm just going to turn it over to Ms. Ledoux so you enter your plea, and then we'd like to hear from your lawyer and further discussion before we make a decision. Mrs. Ledoux. Mr. Smith, you were, alleged to have violated your condition of parole. Condition number 4, you engaged in criminal conduct when you committed the offense of domestic abuse battery, as evidenced by your arrest by New Orleans Police Department on or about April 29, 2025. On May 29th, the district attorney's office refused the domestic abuse battery charges. How do you plead to this?
Not guilty, ma'am.
Okay, so to clarify, you were arrested for those charges and you're pleading not guilty to the action that precipitated that.
Yes, ma'am.
Righty. Would you like your attorney to make a statement on your behalf? Or would you like to make a statement and explain what happened at that time?
Yes, some misunderstanding. And
One moment, please. Eric, they asked you 2 questions. They asked if you want me to speak, make a statement on your behalf, or if you want to make a statement on your own behalf. So what are you choosing to do, Eric?
well, you can speak.
Okay. So at this time, I'll go ahead on and make the record. And for clarity, would you all like me to address the incident that precipitated, or would you prefer additional information?
Whatever you see fit that will enlighten our decision making.
Thank you. Well, I want to begin with what I believe Eric represents. I believe Eric represents a Department of Corrections success story, because Eric demonstrates or exhibits successful rehabilitation. Eric was paroled on December 8th, 2024. He checked in for the first time with his parole officer on December 10th. In early January, about a month after checking in, after having not been able to find a job, Eric enrolled in school at the Deep South Center for Environmental Justice so that he can obtain certifications to become an environmental worker. This is an intensive 12-week program, Monday through Friday, 8 a.m. to 4 p.m. Eric successfully completed the program. His counselor there at Deep South Center for Environmental Justice advised me that they had emailed in a letter of support for Eric, and I'm not certain if you've received it. I have a copy of the letter, and it is a glowing letter. It says that Eric embraced the challenge of the program. He demonstrated hard work, integrity. He was responsible. He was accountable. And he, by all accounts, he's an exemplary student. He completed this program in April and began the job search. The Deep South Center for Environmental Justice started lining up jobs for him, and he started doing interviews. Eric went to do a background check for an apartment and a potential job, and then it was found that there was this arrest warrant in place for him. Eric presently has job prospects lined up in the pipeline, according to the Deep South Center for Environmental Justice. They have also secured funding for Eric to have housing. The TCA, Total Community Action, has committed to make a deposit, as well as up to 3 months rent for Eric as he gets on his feet. And he also has strong family and community support. Now, regarding this incident of his arrest that caused his parole to come up for possible revocation, is there's an incident with the lady that he's in a relationship with, a romantic relationship with. She found pictures of another lady on Eric's phone and became angry. And the lady on the phone resembled the lady who lived next door to the lady, to Miss Cyprian, who Eric was in a romantic relationship with, and she, you know, that angered her. According to my client, she threatened to call the police on him because she knew he was on parole and it would possibly get him in some trouble. When I met with Eric to discuss our defense for this matter, Eric asked me in no unclear terms not to paint her in a bad light, not to make her out to be a bad person. Eric understands that Ms. Cyprian has some mental health challenges that sort of causes this type of behavior from her. But he knows that she's not a bad person. So in his heart, he doesn't even want me, his lawyer, who's fighting for his life, to paint Ms. Cyprian in a poor light. If you all looked at the body cam video of this incident of, you know, when the police came out to take the report from Ms. Cyprian, there were two videos. One was like 20-something minutes in length, but the longer one is 34 minutes and 22 seconds. If you look at the 32-minute and 30-second mark, the officer notes to his supervisor that Miss Cyprian was not very cooperative and didn't really want to participate, even though she was the one who called the police. And then around the 33-minute and 10-second mark, he notes that she told him Eric punched her, but on that video at the 33-minute, 10-second mark, he says, "I do not see anything from a punch." Now, that differs from his report, where he wrote that he observed a bruise as a result of Eric Smith punching her. And he stated that he showed a video of it. But we have two different accounts. His body cam video says one thing in real time when he was first taking this report, and his report says another thing. Ms. Cyprian has not cooperated from the day she made this report all the way through May 29th, from at the time when the district attorney's office refused these charges. I want to suggest to this honorable board that it would be unjust to deprive this man of his liberty on the account, on an uncorroborated account of a witness that is no longer cooperating and appeared to not want to even corroborate at the time of the report. I'm asking this board to follow the decision, or not follow, but recognize that the original panel that heard this account, that conducted this hearing, voted unanimously not to revoke my client. And I'm asking that this panel do the exact same thing.
Thank you, Mr. Bello. Are there any questions of Mr. Bello?
No.
I would like to take a moment to review the video that was the second video that Mr. Bello referred to at the 32-minute, 30-second, and 33-minute, 10-second point. So stand by, Mr. Bello. We're going to go off record for a moment to do that, and we'll be right back with you.
Thank you very much.
Okay, we're in the Wayback Machine just a little bit, so I can nudge us forward. Hang tight while I nudge us forward, so we don't have to sit here in silence. Right about there. Okay.
Smith, I think you made a very poor choice when you decided to live in what I would consider an unstable relationship. That wasn't a wise choice, in my opinion. However, I don't see clear and compelling evidence of injury. My vote is going to be to not revoke, to continue on parole, that you have to have a curfew from 10 to 5. I don't think they're doing environmental things at night. You need to have a stable housing situation. Okay. Yeah. And no contact with the victim and the crime, the Cyprian. Okay.
Yes, ma'am.
You agree with those conditions?
Yes, ma'am.
Okay, Mr. Byron.
I'm going to concur with Ms. Ledoux, but also add a condition of anger management evaluation.
Okay. And I do agree based on the information that we received today. My vote is the same. Do not revoke those special added conditions. Good luck to you, Mr. Smith. Thank you, Mr. Bello.
Thank you. Thank you all very much.
I'm going to sign off at 9:23 for morning.
Thank you.
Approved? Well, alrighty then. Let's go to Michigan. We'll go to Judge Middleton. This is from a little earlier this morning, so a little bit in the Wayback Machine. And Lady Jack's Paranormal, thank you for becoming a channel member. It is great to have you here. I'm excited. Today's a good day. It's a really good day. Good community, lots of generosity, new members. I like this place. Thank you for letting me have this place with you guys. Seriously. If it weren't for all of you, I'd just be some balding guy in his 50s yelling into a microphone. So thanks so much. Let's go spend some time with Judge Middleton.
And James Kuhn. Have a seat, sir. You'll be more comfortable. Mr. Kuhn, you were placed on probation on a charge of operating while impaired. File number here is 241568. You're Ashton James Kuhn?
Yes, sir.
All right, the probation violation petition here alleges that you were charged with operating while impaired, and essentially you got a new drinking driving case. One article is not to violate any criminal law of any unit of government. You failed to pay your fines and costs, failed to abstain from use of alcohol or drugs, failed to participate in treatment as directed. Do you have a lawyer in your new case?
Negative, no.
Who?
Negative, no.
TRPG is still I talked to the prosecutor this morning and they're still reviewing the drunk driving case.
When was it?
Back in June. I'm not sure why it's taking that long, but.
So it was a three-hours case?
That's my understanding, Your Honor.
Anyway, at this point, Mr. Kuhn, this is just an allegation that you have not successfully completed your probation. Some of it's pretty straightforward. You haven't paid, you haven't gone to treatment, but getting a new charge would violate your probation. There's no sense to have you on 2 probations. So we also have you on our sobriety court radar. I'm not sure what's going on. I didn't get a good read on you when I took your plea. What are you doing now? Are you working someplace?
No, sir. Want to keep going?
Yeah, when did you last work someplace?
The last time I worked, I resigned from a job in fielding, testing plants. I left and resigned
It's been a while. It's been on unemployment. I've been living on the streets for 10 months in my suburban. It was a little rough for.
Well, that's not good. The reason you don't have any money is you don't have a job. Have you applied for other jobs?
I go on Indeed and I'm trying to find the best job it's quite acquaintable for myself.
You need to take any job. You need to go to McDonald's. You need to work third shift at a plastics factory. You need to do something that will make you not live in your car.
Yeah, I'm okay now at the moment. I'm focused on more of my health.
Are you back at the Hutchinson Road address?
Yes, sir.
All right. Well, I'm going to appoint an attorney. Set a PV hearing. Daniel, how'd you find out about the new case?
I received an email and he came in and also told me pretty quick, within like, I think 4 or 5 days.
Oh, very good.
And the offense was on June 17th of this year. The new one.
All right, I don't know the date right now when the PV hearing is going to be, but I'm gonna send you out to the counter. They'll appoint a lawyer to assist you with this and we'll set a hearing. In the meantime, maybe we'll find out what's going on with the other charge. But that's the last thing you needed right now. When you say you resigned the other job, when was it? 2024, 2000?
It was like maybe a month ago.
Oh, so it was recently.
It was, yeah, right towards the summer.
All right, and where was that?
It's Bayer. Bayer.
That's a good job.
Yes.
The place up on the way to Richland?
Yes, the big facility.
Yeah, that's a real good
It
job.
was a real good job. I couldn't tolerate disrespect in a respectful manner. I was being treated poorly. I'm pretty highly valuable and worthy for that job, and I just couldn't.
All right, well, all right. Now it's a condition of your probation. You're not using the alcohol. You're still on probation.
Yes.
So if I give you a test right now, what would it show?
Clean.
How about marijuana?
Oh, gross. I'm clean.
All right, good. You, Dan, you need to see him.
Yeah, we spoke. He's gonna talk to me after this.
All right, you're good to go.
Thank you, Josh.
Go out to the counter and Dan will see you.
Thank you, Aaron.
All right, thank you. Yeah, that's a high-paying job, or was. Mr. Bird Beckett, would you come forward, please? All right, this is file number 24523ST. People are Edward Roland Bird Beckett. That's you, sir?
Yes, sir.
You're older than the last guy and you got more life experience. And you've been also struggling with alcohol addiction issues. You got charged with operating while intoxicated on July 8th of 2024. Your agent, Autumn Kiefer, says that you failed to report on a monthly basis. You kind of fell off the map. Sounds like you're back on the map. This is an allegation. Probation violation is not a separate crime, but it could result in a jail sentence. As such, you have a right to have a hearing, or it must be established, at least beyond a preponderance, that you violated your probation. You're entitled to have an attorney at that hearing if you wish. The last gentleman pled not guilty to the violation. I appoint an attorney for him. Ms. Kiefer, what's the status here?
Mr. Bird Beckett contacted my office yesterday. We spoke. He admits that he hasn't reported since May, states that he went on a different shift at work. He needs to complete an assessment. It states that he did that at the most recent rehab inpatient that he completed last winter. So he was going to try and get me a copy of that. He's been told he needs to report on a monthly basis and he needs to pay his fines. We also discussed the fact that I want him to test at DRC today upon his leaving here at the court.
All right, where are you working?
Right now, Ford Blue Oval plant in Marshall.
Right,
He's a union worker, Your Honor.
okay.
Yeah, they shipped me all over the place, but that's where I've been since like March.
What are you working, what kind of, is it construction?
Fitter.
You're working on the construction of the plant?
Yeah, I'm doing the power plant for the facility.
All right, well, that's also a good job. You're no dum-dum. You are wise enough to know you got an alcohol problem. You've been to rehab a couple, I didn't make you go. You checked yourself in. You've actually been in inpatient treatment since I've seen you last. Is that correct?
Yes.
Well, I commend you for that. If you're making $35 an hour, you ought to be able to pay on your fines and costs. What do you want me to do with this, Autumn? Because I got 82 days of jail hanging over his head. I think I should appoint an attorney for him.
If he wants to admit to failing to report since May and he's negative today, I'll keep him on the probation. But I need to get a substance abuse assessment from him as soon as possible.
Didn't we discuss sobriety court in this case?
We did. He doesn't have a valid license out of California. Indicated to me yesterday that he's working on that as well. Has to pay fines for that too. And
all right.
My work schedule wouldn't allow me to come here.
It's a regret. I think we could have done some work with you, but there were logistics. You wouldn't be able to get your license anyway. You lived in Kalamazoo County. You work construction. I think last project was Gun Lake Casino.
Yes.
And so it would have been unworkable for you to do it. I think we could have.
This project is actually quite a bit more intensive.
Well, it sounds like you may be there for 5 more years. What's your trade?
Motor pipe fitter.
I underestimated what is it? Yeah. All right. All right. I'm going to show a plea of not guilty. Appoint an attorney instead of PV hearing. Now, you heard what your PO said. We're going to test you today, but you're back on track. You've contacted us. If you can get what we need to do, I can get off your back. I put you on probation a year ago. And, but I got 82 days of jail hanging over your head, which there goes your job at Blue Oval. So if you get back in good graces, maybe we can finish this probation and discharge you. When did he last make a payment?
he has not made a payment.
Oh.
That's what I told him. I mean, he's been on for a year
Yeah,
and is making good money, but he claims right now that he's paying 2 house payments,
Well,
trying to get a license back.
I can wipe out his fine with 82 days of jail. You need to buy a ticket on the Clue bus and get on it. I got 82 days of jail hanging over your head, so you need to take this more seriously. Like I said, if you can get back on track, we can complete the probation and discharge you, let you go on about your business. I've had a lot of trade guys over the years. They work really hard, and then sometimes between projects, there's dead time and less income. There's also a lot of drinking after work. They finish a 10-hour shift, they go out for beers and dinner after work. They get up the next morning and do it all over again. After a while, it catches up with you.
Well, it caught up with me a long time ago. I haven't been doing that.
Like I said, you're wiser than that last kid I talked to. You got enough bumps on your head that you realize it hurts when you get hit with a hammer. And you've done some things to try to deal with it. But I want you to take this more seriously. And I'd like to get to the finish line rather than have you do 82 days in jail. But I'm offended by the fact You haven't paid 5 cents in a year's worth of probation.
I had several ticket fines that I paid before when I came in last time.
All right. Well,
That was several hundred. And no, I just, honestly, the time it goes pretty quick when you're working night shift. It's.
all right, you go with the court
Lost track
officer,
of
Autumn.
days.
Do you need to see him further?
We discussed yesterday.
All right,
so
you need to
it's
go to
good.
DRC before the morning's out. We'll see how that
And I
goes.
can make a payment towards what I owe today.
Very good. All right, you're good to go.
Thank you, Your Honor. You're gonna make a payment, you go downstairs.
So an update for you. While he's between contestants, earlier this morning we mentioned two things. There was that school bus accident, and then there was separately a shooting at a school bus stop where an adult was shot. Initially, the reports were it was as many as 3 gunmen, but the latest report I saw was that it was maybe only 1 gunman, but it was a 15-year-old who did the shooting. So I'm going to keep looking for information on that and see if I can find something a little more nailed down. But whatever happened there is certainly not good, and this country needs to just calm down a little bit, or maybe a lot of bit. Was just looking at Judge Glazer. She worked past lunch. She finally took a lunch break, which is good, because we know what happens when she gets hangry. Let's go back to Judge Middleton.
Edwin Otto Smith at 1. Well, I might as well stay where I'm at. I theoretically have another case at 10, and I have a 10:30. And then I have 1, 1, 1, 1. All right. Let's get some stuff out of here. I would have liked to have had that last guy in sobriety court, but we weren't able to make it happen.
Okay, I do have an update on that. This is off of X from the Louisville Metro PD. Around 8 a.m. at 10th and Chestnut Street, an individual fired shots near several people going to school and bus stops. A woman walking with a student was shot. She was taken to University Hospital where she died from her injuries. LMPD has arrested a 15-year-old in connection with today's shooting. So, there you go. Not what we're looking for. Let's go back to Louisiana. Let's try Louisiana again.
To consider the case of Mr. Kentrell Parker. Mr. Parker, can you hear me okay?
Oh, wow.
All right, would you tell us your name and DOC number, sir?
Control Parker, 37-1212.
All right, Mr. Parker, and we're here today for consideration for a medical treatment furlough because you've been recommended for a medical treatment furlough. And you have your attorney there with you in Angola. Mr. Foster, would you introduce yourself for the record?
Yes, Matthew Foster. I'm here representing Kentrell Parker.
And we'd like to hear from you shortly, sir. We're going to get some information and then we'd like to hear from you. Let me just acknowledge here at headquarters, we have Mr. Michael Allen with the Promise of Justice, and Mr. Rich Webster. Welcome. We appreciate you all being here. On Zoom, we have Mr. Norris Henderson who wants to be speaking. We'll call on him shortly. And then also there at Angola, we have family and friends, Ms. Kirka Parker, Samantha Pusho, Edward Johnson, and Janice Parker. First, before we hear from the medical staff, Mr. Parker, I'm going to read some identifying information into the record. You are classified as a second felony offender. You're currently serving a life sentence at Angola for a sentence of you were convicted in Orleans Parish in December of 1999 for a second-degree murder. Is that information correct?
As well.
All right. So we'd like to hear from the medical staff. Can you tell us about Mr. Parker's condition?
Yes, ma'am. Mr. Cantrell, he's 47. And about, I think, February 19, 2010, he was involved in a cervical injury that basically left him quadriplegic. Since then, he's developed a neurogenic bladder that basically requires a chronic suprapubic cath, some constipation, diabetes, hypertension, high cholesterol. But he's basically total care. He's going to need assistance 24/7 to feed and care for him and clean for him based on that injury about 15 years ago.
All right. Mr. Foster, is there anything you'd like us to know before we ask our questions of the medical staff?
No, I can defer to them to go over the medical information first before I speak.
Okay. And Mr. Henderson, what would you like us to know?
Good morning, Ms. Renato, Ms. Ledoux, and Mr. Bowers. I was a Cantrell football coach. And for the last 20-something years, I've been, it's one thing a person get hurt on the field, and the person on the sideline looking is kind of like traumatized by what they see also. I've been not just a family friend, but, I coached him for years. And so when this tragedy happened, it just took the wind out of us. It was the first time somebody actually got hurt playing intramural sports in the prison to this extent. And I just want the board to know that I have been trying, ever since I've been home, trying to do everything I can to help Cantrell's transition from the prison to here. I don't know how many conversations I've had with people, different wardens, secretary, even the governor, and trying to kind of like move this thing. Trell is, was a very athletic kid. And to see him the way he's been for the last, almost 2 decades now, it's just kind of like just heartbreaking. It's kind of really tears at me every day. I mean, every time I watch football, the minute somebody get hit, my first thought is Trell. And so I would just hope that this board, given what the doctor just said, that Trell is going to need 24/7 care. His mother's here, his sister, his family, and then his extended family. His extended family is all these guys who played ball with him that's going to be there to help this family deal with this. This is not like something that, you just wake up the next morning, it's like, oh, it's something I'm prepared to do. But I think given over the time that we have been struggling, trying to get Trell to this day, I think we've built up the resources that we need to be able to help Trell transition. Personally, I'm gonna do everything I can. Our organization, giving the resources that we have available, I would do everything to help this family, help Trell be as comfortable as he can be, given his circumstance. What that looks like, I don't know. I think one of the assets that I also bring is that I'm a former hospice volunteer. So I know how to take care of patients. A lot of the guys that was on our team are former hospice volunteers that's home. And so we know what that care looks like. Because some of our guys, before we got out, we took care of Trell. And so it's not something that is something new to us. This is a kind of continuation of something that we had already done. So I would just hope and pray that this board really consider this medical release for Kentrell. Because again, it's like right now, he's really a burden to the state in the sense of somebody have to 24/7 care. It's not like he's just a regular patient on Ward 2. He's a patient that needs all the patient care that he needs 24/7. And, you know, given that, again, tragic accident, nobody planned for these things. But, you know, I always tell people that, you know, man plots and plan, but God the best planner. So, you know, we can't put this beyond, I mean, God know what he was doing, we're not questioning that. But I think it kind of like give us the opportunity now to do something that can kind of like not make him whole, but at least to kind of like rejoin him outside the correction environment where his family can actually provide him with the TLC that he actually needs. Not that he's not around friends that care about him, but to this other extended family of friends that can really help him. And first of all, I want to thank y'all for really just kind of giving me the latitude just to kind of like, you know, just talk from the heart about Trell because, you know, it's like my son, you know, it's somebody you coach. I coached him for 10 years playing football. And it was kind of like this experience of camaraderie that we done everything together. I mean, from season to season, we wasn't playing football, we was playing softball. We wasn't playing softball, we playing volleyball. We wasn't playing volleyball, we playing basketball. And over those 10 years of me interacting with him, it's like I saw him like he was my son, you know? And so it's just like I would really appreciate the board's deep consideration and, you know, granting release to him today. And, you know, it's just a challenge. I mean, it's a challenge for me just to see him in the state that he's in, knowing how talented he was and what he brought, not just to the athletic field, but, you know, he's this outgoing, gregarious person. He was a fun person, you know? And I kind of like just, you know, it's just kind of like hard today to really just, I don't, be honest with you, I've been a part of a lot of hearings, and I just don't know, be honest with you, is that what else I can do in this moment for him. I just don't. I really don't. And it's just kind of like this. It's just hard, but.
We appreciate you spending time with us this morning, Norris.
Thank you. Thank you very much. Thank you.
All right.
To blame for the end.
We're gonna, I'm gonna turn it over to Mr. Byroff for any questions he may have.
I don't have any questions. The facts of the case speak for themselves. We got a recommendation from prison medical staff that medical treatment furlough was recommended, that the condition will not improve, that he will need complete nursing care for the rest of his life. I'm looking at the report from the victim assistance coordinator, where the victims, the deceased, did not want to participate, did not want to make a statement at this time. So we have no real opposition from the victim family. So I'm ready to vote whenever y'all are ready to vote.
Okay, Mrs. Ledoux.
I would like to point out, Mr. Parker went to a nursing home previously, not long after the incident occurred, and then was returned to Angola. Can Mr. Parker address that?
Yes, ma'am. I was at a nursing facility and I made a bad decision. And I feel like a changed man. And I wouldn't make the same mistake that I made before.
Okay, I'm going to address one more thing. I'm doing this because I want you to recognize we have read this file. You had a write-up in 2020 because your mouth got you in trouble. Being ugly to one nurse.
Yes, ma'am.
That concerns me. Because you're going to be dependent on these people and you can be abusive to them verbally. You understand how that's not going to be acceptable?
Yes, ma'am.
Right. Mr. Foster, anything you want to add?
Yes, I guess I would like to note that the particular statute that would empower the committee to grant furlough in this case would be Chapter 15, Section 574.20, in particular subsection 2B, which defines limited mobility offender as someone unable to perform activities of daily living without help. That would be that would define Kentrell Parker. And the statute goes on to describe the conditions that should be met, that the offender is not a flight risk or a risk to public safety. Kentrell is not a flight risk or a risk to public safety, and the former write-ups that he had wouldn't rise to the level of being a public safety risk in the sense that it should impact the committee's decision on furlough. Furlough is also revocable. So if there's a concern that something could happen in the future, the committee's decision today isn't permanent. So hopefully the committee will grant furlough. It'd be the right thing to do to ensure his medical care and also ease the burden on the prison and save the state money. Thank you for your time.
Thank you. Thank you, Mr. Foster. Now, we are considering, just to expand further for our viewers, the medical treatment furlough requires placement in a nursing or medical facility. It's not to go home to anybody. I think we're prepared to vote. Mr. Byron.
Mr. Parker, today I'm going to vote to grant your request for medical treatment furlough based upon the fact that there's no strong victim opposition and that you're recommended by the medical staff.
This is legit.
Because you require complete assistance with ADLs and pose no public safety threat, my vote is also to grant to your medical furlough.
And I didn't ask Warden Benoit, is there a particular medical facility that you have worked out?
No, ma'am, they're waiting to hear from, they've contacted some nursing homes. Several have turned it down, but they're waiting to hear for some more.
Okay,
They turned it down because of his level of care, they couldn't provide it. The only place that we contacted.
Okay. Well, my vote today also is to grant the medical treatment furlough upon, finding a suitable placement for his care. So
we will be looking very hard.
Okay, thank you. So, Mr. Parker, you've been granted a medical treatment furlough. Good luck to you.
Thank y'all.
Approved? So a couple of points of interest. First point of interest, correct me if I'm wrong, but I don't remember a single instance on this channel where we've had 2 approves without at least having twice as many denieds in a single day. So that's really weird. Also, what I found interesting was at the very end where the one board member said, and for our viewers, and then explained something. Love them or hate them, and we've had mixed feelings about them. I appreciate the fact that this board has always put themselves out there. They don't hide. Every proceeding that they do is live streamed, and they don't take them down afterwards like so many judges do. It's there for you to review later on. So, I appreciate that. And I appreciate the fact that she clarified for people watching, too, exactly what that furlough meant so that they would understand. So, kind of cool. Let's go back to Judge Middleton. I think he's got another contestant now.
People versus Travis John Andrews. Is that you, sir?
Yes, sir.
Mr. Andrews, you're here with your lawyer, Mr. John Bush. Also present is your probation officer, Matthew Huff. This is set for a probation violation hearing. Have we resolved the case?
He is going to be making an admission to one of the counts today.
All right, very good. The prosecutor isn't here if we had to actually conduct a hearing, but it appears he's going to accept responsibility. This is an interesting and difficult case. Mr. Huff and I have discussed this several times during the term of this probation, including yesterday. Let's go back to square one here. Probation violation petition alleges that he violated his probation. He was placed on probation on September 30th of 2024 on a charge of domestic violence. He, as I recall, headbutted his girlfriend out at Long Lake and threw her phone in the lake. He was placed on a domestic violence deferral probation, and it didn't go very well. The allegation is he violated a criminal law. He got charged with a felony drug possession charge in Cass County, and he failed to report. What primarily started it was he failed to report. He was placed on probation, and then we didn't see him. Failed to report October, November, December, and January, and no reports since. Then they learned that he'd been charged with a charge in Cass County and is facing, I'm not sure what the status of that is. They were considering placement at their mental health court. I also ordered that he do the domestic violence treatment program. That's not in the petition. Did he ever do any of the treatment?
No.
All right. At some point he returned, he'd been AWOL, and then at some point Matt reestablished some contact with him. I did the arraignment on June 11th with Mr. Stickley. We learned that the defendant had been at the VA. We actually did the arraignment from the recovery center at the VA in Battle Creek by Zoom with the defendant. And we set a hearing which resulted in this hearing. The defendant at that time also had charges pending in Cass County. Matt just gave me this report, which is in microscopic print, indicating that the defendant had been in some treatment at the VA. So we go forward too far, I would note that Angelique Camfield from the prosecutor's office has joined us. Mr. Huff, what's our current status?
Well, I had no contact with Mr. Andrews from the point of the probation violation arraignment, which, as you noted, was on June 11th at the Veterans Treatment Facility until yesterday. So I've had no contact. He indicates a couple of things are going on new, that he was released from treatment approximately 2 weeks ago, end of July, and that he's set to go back to another treatment, post-traumatic stress disorder program, September 17th. Apart from that, I don't have a lot of information, and perhaps Mr. Andrews or his attorney could shed some more light for you.
All right. Mr. Bush, can you tell us what the status of his Cass County charges are?
It's my understanding that they're set for trial on October 24th of 2025. He said Greg Feldman from Edwardsburg is his legal counsel.
So you had a preliminary examination and the matter got bound over?
I believe so. Yes,
all
sir.
right. Boy, they get things to trial fast in Cass County, if that actually goes. All right, Mr. Bush, what's our plan for this morning?
Obviously, he's in no position to make any admission regarding the new charges, but for purposes of probation violation, he would admit that he failed to report and contact Mr. Huff.
Sorry about that. I brought my phone in here to scan a driver's license. It's going off. All right, Mr. Andrews, as I told you before, you have a right to have a hearing regarding this violation of probation allegation. And Mr. Bush, your original lawyer, was reappointed. Also, at that hearing would have the matter established at least beyond a preponderance of evidence. Frankly, this isn't going to be very hard to prove that you didn't show up for months and you didn't do the treatment that was ordered. So you also can simply admit that. Is that what you wish to do here this morning?
Yes, Your Honor.
All right. Tell me what happened. I put you on this probation. I had good thoughts of a domestic violence treatment program. We never even got the balloon 1 inch off the ground. What happened?
From there, the person that was involved with this and I split up and I kind of spiraled out of it, mental health crisis. Isolated for months in home.
Out at Long Lake?
Yes, sir.
You still have the house on Walnut Drive?
Yes, sir. I just kind of shut down. I said I was just in a serious mental health crisis at the time.
That sounds like it. Now, the charge in Cass County is methamphetamine?
Cocaine, sir.
Cocaine, neither of which you need, but.
No, not at all. There are a lot of poor decisions and a lot of people that are important to be disappointed.
Well,
Tell him how you got to.
so then at some point you got back on the horse. When I saw you in June, you were at a VA treatment facility, and I talked about your service in Iraq and other places and PTSD issues and other things that you're dealing with. So when did you go into treatment at the VA?
I went into the inpatient mental health ward first, just kind of get stabilized, and that was 12th of May. I spent a week there. I went home for a week, and then I came
Now
back.
that was after your Cass County arrest?
Yes, sir. I kind of hit rock bottom with that.
Sometimes that's what has to happen. You have to hit rock bottom to start to climb back up. And so then, Matt said, I haven't heard from these people. We got, the PV when you were at the VA, then you got out of the VA, you didn't contact him, and then heard from you yesterday.
Then in June 2nd to 30th, I did a 28-day inpatient recovery program.
So there's two things going on. There's your mental health issues with PTSD and others, and there's addiction issues. What is the recovery from? Cocaine, alcohol?
Cocaine.
Okay. Cocaine had fallen off the map when I was a very young prosecutor. It was heroin in the 80s, early black tar heroin. Then it was cocaine. Then it was crack cocaine, which we thought was terrible, as bad as it got, till methamphetamine showed up. Then cocaine seemed like a distant memory. We also had lots of marijuana cases, but we thought crack cocaine was bad stuff, which it is. Then we get Oxycontin and prescription opioids that they were passing out like M&Ms. And we dealt with thousands of people with opioid problems. And then we get fentanyl, which kills people. So it's been a tragic progression of substance addiction and harmful substances, not all narcotics. Cocaine seems quaint now, but it is very addictive and involves effect of your mental health. All right, so you got a lot going on. You got a case pending, you've got counsel in another county, you're connected to the VA, you've got further treatment planned, but this probation was a dud. We didn't really accomplish much of anything, particularly regarding domestic violence treatment. In light of his admission, Mr. Huff, what's your recommendation?
Well, this is a very difficult case to make a recommendation on for a couple of matters that have been highlighted already. First and foremost, I mean, some of what he's going through obviously stems from his service and the post-traumatic stress that he suffers from as a result of it. So I think there's a certain amount of empathy that ought to be extended given the context of his situation. But we also have to consider the fact that there's a victim in this case. And I do wonder if the victim was sitting here in the courtroom, what she would say. What she would say needs to happen in order to get his attention, because obviously this was someone that he had an intimate relationship with, and probably somebody who they both cared about for a while. But the bad stuff that was going on was enough to make a permanent split. I think that this was probably always about mental health and substance abuse. That's probably why the split happened. Maybe I'm wrong, but again, we don't know a whole lot when I don't have communication with a probationer. I'm a little bit concerned, again, there's a gap where I have to fill in the blanks there and wonder what happened from when he was released from treatment. And then he calls me the day before the probation violation hearing. I am encouraged that he's willing to admit that he's responsible for these actions and that he wants to, I guess, curb this sort of behavior from his life. But at the same time, there needs to be some sort of ramification for his actions. I don't want to deprive him of going to the post-traumatic stress disorder program at VA in Battle Creek. So first and foremost, I would say if the judges, or if the court's inclined to impose a jail sanction, that it'd be less than the amount of days that it would take in order for him to go to that program, because I don't want to see the court, obviously anything that happens, he's earned. However, I don't want to see us get back in the way and have him go down again. I think I use the analogy, I don't like to hammer people who are back on the upswing. But this is a very difficult situation. I don't think his history is conducive with the probation. I don't think the probation should be continued. There's a non-public status attached with this, I believe, as well. I don't think that you can go out and get a new charge, abscond, and have several positive tests, several missed tests, and still have a probation go through successfully. I just don't believe that that is the spirit of what probation is designed for. So I think some jail is appropriate. I don't think a lot of jail is necessary to get Mr. Andrews' attention. I think we have his attention right now, but I would give my input there. And then I also wanted to make one note too about the request for release of information that I provided the court with. I showed Mr. Andrews' counsel the exact same document ahead of time. A little bit concerned because it's kind of like a half authorized information release. It shows that they can give us discharge dates and acceptance dates, but they can't talk to us about what sort of treatment they're doing or any intimate details. I don't need to know ever with any of my clients what they're talking about, the topics. But the second box that's checked on there just basically says, like, unless it has to do with drug abuse counseling treatment, I don't want any information given to the courts. And so I'm sure, if I talk to him, he'd probably be like, oh yeah, I want to check that box, or I'll sign something different. But that's why I provided the court with that. I just wanted to make that clear.
All right, we'll hear from the prosecutor and then we'll hear from Mr. Bush and the defendant. Ms. Camfield, do you have any input on this?
Your Honor, mental health concerns are always difficult for the court and probation agents to deal with when They may be an explanation for assaultive behavior, but certainly not an excuse for it. In this particular instance, as I'm reading the report, it indicates that she may have had a broken nose from being headbutted in the face by this defendant. Children were going to be coming over later. He just failed to do anything that he was supposed to do. He's aware of that. He's indicated to the court why that occurred, and did subsequently get himself into treatment programs which were appropriate. But again, we have him having committed an offense and being put on probation to rehabilitate from it. And while he is getting mental health treatment with the VA, it most certainly is not the domestic violence therapeutic program that this court ordered. And I'm sure that that particular instance may not even be addressed to the extent that it would have had he complied with his probation here. Whether or not they're still together and whether or not that was a toxic relationship is not as important as how do we rehabilitate him not to be violent with another partner in the future, and also give a consequence for what he did to his previous partner. It was a pretty serious assault. He's failed to comply with this court's order. So I do agree with Mr. Huff that jail is appropriate. Under circumstances of this, if there weren't a mental health component and he hadn't availed himself of the VA services over this past summer, I would have recommended the maximum time in jail for the offense, in addition to the revocation of the deferral program and the entry of the conviction. At this point, I'll leave the jail to the court's discretion, understanding that he's got a program waiting for him, but also knowing that he needs to have a severe consequence for what he did to this victim, as well as just ignoring this court's orders for the duration that he did.
All right, Mr. Bush.
May I do this seated, Your Honor?
Yes.
Mr. Andrews shares with me that he served in the Air Force from 2003 to 2012. He was medically retired with a 90% disability. Hence, he's not a candidate to go into the competitive employment world. He shares with me that since his release from the VA substance abuse program, he's been doing weekly online counseling with the VA counselor. It's also been brought up by Mr. Huff that the plan is for him in mid-September to go to the PTSD program. That's a 5-week residential program. Those are all matters that he wants to complete. He shared with me today that he had no intention to restrict Mr. Huff's office or the court on his release to the VA. And if for whatever reason the program is continued or the probation is continued, he will willingly sign a new release that gives Mr. Huff free access to his programming. But with all that in mind, it doesn't look like the probation is going to be successful. The revocation is certainly probably the likely result. There has to be a degree of punishment. I don't think anything greater than at least 6 or 7 days needs to be done based upon the services that he has endeavored since the time. Thank you.
Mr. Andrews, anything you'd like to tell me?
I don't ever like to use my service as an excuse for bad behavior. I got injured doing my job. Never really fell apart until recently.
How are you doing with cocaine?
Got 104 days today.
All right. There was a little unspoken piece here. It was acknowledged that he threw the complainant's phone in the lake. And I remember she had a victim impact statement, and I was concerned about restitution. She wasn't here. She asked for a bunch of other stuff. AirPods, swimsuit, hand-blown glass piece, emergency room CAT scan, canopy tent, air mattress, missed work. So I reserved on restitution, intending at some point during the course of probation to go back and visit the restitution issues. And certainly the phone was pretty straightforward. He threw a phone in the lake. But all the rest of this stuff I wasn't clear about. And as I recall, she wasn't present at the sentence. So I reserved on the restitution. You're not Sarah, are you? Okay. You're here on the Detler case? All right. So I regret we never visited that. So in addition to everything else you didn't do, you never paid her 1 cent for, she had a medical bill, she had to replace her phone.
He shares with me, he did pay for the phone.
You did pay for the phone?
Paid for the phone. I had no idea of the other items at all. And she has all those. Everything that you just listed off.
Well, again, I didn't have enough information to deal with it, so I reserved on it. Here's what she said at that time in her victim statement a year ago in June. In your opinion, what is the appropriate sentence? Anger management in therapy, in big bold letters, all capitalized. We never got there. Therapy, maybe, no anger management. Whatever consequences the judge deems appropriate. He seems to think he only has to answer to himself. He could use a reminder that he has consequences, cannot do whatever he wants, whenever he wants. So we tried this probation, which was a flop. But I'm hopeful. I'm going to revoke the probation and loss of deferral status. It means you can't use or possess a firearm for the next 8 years. Anyway. I'm order 2 days jail starting right now. And revoke your probation. You've got some treatment coming up. You've got charges pending in Cass County. They're considering mental health treatment court, which I think is a good program. Judge Renfro and I think Judge Beeler run that. Anyway, you're going to jail. I'm off your back. I'm waiving your fines and costs. I'm revoking your probation, loss of deferral status. But as your ex says, you cannot do whatever you want, whenever you want. You've been discharged from the service for 14 years. Cocaine got in there and mixed things up even more. But when you get out of jail, I'm off your back. I wish you the best of luck in your Cass County endeavors. I'm not ordering any further restitution because I never sorted it out. Defendant says the phone has been paid for and the other property is returned. All right, you're good to go, sir.
My ride this other jail.
Luke? Or Luke?
All right, friends, I think that'll do it for today. I want to leave us with a view of our bear friends up in Brooks Falls in Alaska. Yeah, there's 4 currently on screen, and there's a few more that have been wandering in and out as I've been watching for about the last half hour. So they're having a good time out. The one up at the top of the falls there just caught breakfast. Good for him or her. Outstanding. Always good to watch the bears. I find them peaceful myself, although what they're doing is kind of violent, but still. Today was a really, really good day. Lot of generosity from the community. We got to make a couple of new friends, got to see some good court cases. Really appreciated today, and I hope you guys did too. The good day will continue. We have several good videos going up as the day goes on, so be sure to be on the lookout for those, and we'll be back tomorrow live twice. I'll be back in the morning, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. And then we have our Thursday edition of Sidebar tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific, so be sure to join us for all of that. Again, thank you so much, everybody. I'm blessed every day to be able to host this community. It's the greatest thing in the world, and I'm so thankful to be able to do it, and appreciate all your support. So we'll see y'all tomorrow. Take care. God bless.